By the way, Linda,
Hey,
it's good to see you.
DeAndre.
You too, sir. Back at you.
DeAndre, you're muted.
Okay, I have added the participants in, everyone. We can start.
Jim?
Oh, I didn't hear that. I'm sorry. Hi, I want to welcome everybody to today's presentation on obtaining a LPS conservatorship. I'm Jim Farrell, and Gail Evangelotti and Linda Boyd and DeAndre Davis from Los Angeles Public Guardian's Office will be with us today and presenting as well. Today's class, as I had mentioned, will be going over the steps necessary for obtaining an LPS conservatorship for your loved one who is suffering from a very serious mental illness. Gail and I want to absolutely express a special thanks to our NAMI Urban Los Angeles Board of Directors for allowing us to share our information with all of you here today. Working behind the scene in today's presentation is NAMI Urban's webmaster, Araceli, and she's orchestrating all the goings on behind the screen, you might say. So I want to let everyone know that today's presentation will be recorded. So consequently, we ask that when you're invited to ask a question later on today, that you not use your loved ones' names. It's a HIPAA violation to do so because we are an official organization. We can't have names mentioned on this program. So we want to protect your loved one's privacy and not violate their rights in the HIPAA laws as well. So note that as we go along, and Araceli, did we vote to leave the chat on?
No, the chat is still active. It's still on.
Okay, so just please note that you can post questions in the chat, but we would like you not to have other people answering questions and getting so focused in the chat group that it takes away from the meeting. So please, stay tuned in. We're going to do our absolute best. And we have a couple of people that are presenting today that will also be trying to answer questions in the chat as they come up. So, all right, with all that being said, Araceli, if you'll move us forward with our first Zoom slide, appreciate it. So that's my slide, folks. Again, here's today's lineup for our presenters. It's Gail Evangelotti. She's the NAMI Urban Los Angeles Conservatorship Mentor. I'm Jim Farrell. I'm from Orange County, and I represent the Orange County Conservator Assistance Group that I run. And also James Kwan, he's the Deputy Director of the Office of the Public Guardian in Los Angeles, and Linda Boyd, who is with the Department of Mental Health Supervisor Care Court program in LA. And also we have with us Venus, forgive me, Venus 9. Can you correct me on that, Venus?
You're correct.
Okay, 9. I got lucky. She's with the Department of Health Supervisor Assisted Outpatient Treatment Program. And so even though today's program is being run by NAMI Urban Los Angeles and the presenters are from NAMI Urban Los Angeles, I will be chiming in on the Orange County side of things, and that the LPS conservatorship laws are the same laws and apply to every single county in the entire state of California. So we may be sharing a few resources that are LA resources, but the entirety of the class and the laws and so forth, it pertains to the entire state. So even if you're not in LA, it still pertains to you. All right, next slide, please. So this is our contact information. Oh, I was going to take it up. Araceli, I'm going to have my email from here on out into the future removed because there's so many scams out there, and emails are a good wedge to get in with. But anyway, if you want to contact us, you're welcome to use the information that's here on the screen. If you have any questions, or if you've heard some of our presenters mention something and you would like to get in touch with them directly, please do so. And we can bring this up again later, maybe in the meeting. So in case you don't have time to write some of these down. Next slide. So basically, this is about acquiring resources for your loved one and their needs for living. You'll want to, well, as a conservator, you would be in charge of their, what they call their SSI, SSDI, all of their financial needs. You would be establishing yourself with the Social Security's office. If they have veterans benefits, you'd make sure that they were in line to receive those. If they've worked before, you know, you would want to establish the SSDI for that, and as well, because your loved one's disabled, the SSI funds, all of which will help pay for their living expenses and their food and their clothing and everything else, medical and so forth. So for insurance, we'll go over Medi-Cal and Medicare and private insurance as well. Next slide, Araceli.
All right, can I just add something on that? Well, I guess
Oh.
I'll add it now.
Absolutely, of
That's
course.
okay. Go ahead to the next one and I'll add it.
Go ahead, Gail.
Okay. On SSI, SSDI, you don't have to have the insurance, or you don't have to have the LPS conservatorship to initiate the workings on it. But when you call Social Security and you're trying to get this information, do not say you are applying. That's very important. The moment you say I'm applying for, and you don't have an LPS conservatorship, they'll say, well, ma'am, you can't apply. It's your loved one who has to sign the information. And many of our loved ones, they're not going to sign for them because they're not sick. You are, but they're just fine as far as they're concerned. So when you call them, tell them that you need them to help you fill out the forms for SSI and SSDI, whichever one. If they have a work history, they may be eligible for SSDI and not a recent work history. It could be a long time ago. They will be able to tell you which one they are available for, or they are, you know, they meet the requirements. Have them help you fill out the forms. Let them know that they're going to be in the hospital. You have about 3 months to get this done. And then when they're in the hospital, you give the forms to the social worker. You be sure to have copies and ask them to get them to fill them out. The social workers are pretty good about convincing them to sign the forms. All right, when you get SSI, Medi-Cal comes automatically. But when you have SSI, be careful that you never allow more than $2,000 in the bank at any particular time. If it goes to $2,001, chances are you may be audited. It's not a big deal, but it's more added stress. You don't need any more added stress in your life. So if you're looking at SSI, that's the money that's going to come in to help pay for their food, their clothing, their shelter, all that sort of thing. So if you know that they're going to be depositing more money and it's going to run over, take that money out, take some of it out so it doesn't go over 2,000. All right, there's a program that Jim's going to talk about later, which is CalAble. And that's a program where you can add money to them and help them out when necessary. But you have to be careful with SSI. SSDI, it is not a problem. All right, when SSI is approved, Medi-Cal is usually granted at the same time. But you can get Medi-Cal prior to getting the SSI. And you can also, when they're in the hospital, you can get emergency Medi-Cal. Every time they go in the hospital, call Social Security and let them know. It keeps that SSI going along, or SSDI. All right, Medicare is also another insurance, and that's if they're under SSDI, they can get Medicare, usually 2 years after receiving the SSDI insurance. So that's usually 2 years. It will be automatic. You just call Social Security, say they've been under SSDI for 2 years. I need you to add Medicare, and they do. Now, if you have proof that they've been ill prior to receiving SSDI, chances are, and going back 2 years, chances are they will approve Medicare at that time. So those are just a few things to do. When you go for SSI or SSDI or any of those, VA benefits, any of them, ask the treating doctor at the hospital, the jail, if they're in a program, to fill out the form for you to be representative payee. Don't go looking for the form on the internet. You don't need to do that. They all have that form. It's basically one page. It's not a big deal. Give it to Social Security and then open up a bank account in both their name and your name. The money going into that account will be shown to income tax, to the IRS as their income, but they do not have access to that bank account unless you tell them. I wouldn't even tell them what bank it's in because they're very clever about getting the money out. So you don't want to give them too much information, but you have control of that money, which is to be used for their needs. Okay. All right. Next slide.
I wanted to share something that
Okay.
I think I find it very, very interesting. And please keep in mind that what I'm about to say is not a recommendation. It's simply an experience, and it's something to think about. Is that for circumstances that were beyond the control of my conservator or myself, they had overpaid us, and then they always come back and want us to pay later. And I had one of the managers of the Social Security office prior to that actually tell me, oh gosh, you have too much money. Well, I just want you to know that, I probably shouldn't tell you this, is that the banks notify Social Security when the account is over $2,000, but they report the bank balance at the end of every month. So if you have too much money in there, Mr. Farrell, just take that money, draw that cash out of the money, put it aside. You'll still have to show receipts and be accountable for it, but just pull that money out so it doesn't go over $2,000. And then just recently, they said we owed all this money and we have too much money in the account. Again, not our fault. And they're telling me, oh, no, don't put it in the Cal Able account. Take that and take the money home. Just keep records on it. And I'm just so amazed that I've had a manager and other people in Social Security telling me to just pull the cash out, and you have to be accountable for it in your bookkeeping at the end of the year, as you do. But I thought, holy cow, that's something new. And I don't know if other people have experienced that, but be very careful about that. Boy, I take down who told me that on what date. You have to really be careful about things like that. Okay.
You really should. And that is
Gail-
a common thing, that they overpay. And there is a lawsuit right now where they're going to have to pay people back because they overpaid. Okay, next slide.
Gail, James has his hand up.
Oh, James, go right ahead. Just jump in.
Oh, okay. And I'm sorry, guys. You guys always do a great job. I just wanted to make sure, number one, I think this is something, especially Linda and I are, very concerned about, is due to budget issues at the state of California, the $2,000 limit for people who have now SSDI, right? They didn't have the same asset limit test as people who were on SSI, because the state of California in 2024 eliminated the asset test for Medi-Cal recipients who are not on SSI, right? So I think the current revise of the state budget is that for all new applicants, that they will be reinstituting that asset test. So even if you're not on SSI, but you're on SSDI, which means you earn credits, but you're just not at the age of retirement, and you're receiving Medi-Cal separately, you're also going to need to heed Gail and Jim's warnings about your monthly amounts, that you keep that below 2,000 for a single person and 3,000 for a married person. Most likely that's going to be in place starting next year. So I just wanted to people, don't take that as 100%, but at this moment, that's what the state budget looks like. So please be warned that even if you're only getting SSDI and Medi-Cal, those same asset limits will be applied, especially if you're a new applicant to Medi-Cal.
And that starts January 1, so it's right around the, even though we're heading into summer, it's right around the corner.
Mhm. And then
Is
the
that
other
just
thing,
for new applicants or is that for old applicants? Old
so
people?
far is for new applicants, is what I'm understanding. When we have more clarity, I'm sure NAMI will also find out around the same time. But when we have more clarity, we will definitely let people know, because that's going to affect everybody, right? But I think it's going to be
Right.
new
James,
applicants for now.
thank you.
And then
Thank
just
you
the other
so
thing,
much for letting
oh
us know.
no, it's very important, especially for our private conservators, to not
Yes,
lose that benefit. But Jim, I wanted to kind of just
right.
back up what you said in a more formal way. Is the Social Security Policy and Operations Manual says ledgers, the balance that's reviewed is at the first moment of the month. So exactly what you said, but that's the official way that Social Security reviews your balances. So any action that might have occurred within the month may be more forgivable if kind of teeter over that 2000 mark. But the way that they check your bank ledgers is on that first moment of the month, meaning 12:01 a.m. The next month, with July 1st, is when they'll look at the ledger and say if you were over the limit or not. So please be aware of that for your record keeping purposes.
So I guess what they
Excellent.
were saying too is before you get to the end of the month, pull that cash out so that that balance doesn't go over to Social Security. They may look at it on the first, but prior to the end of the month, it's the bank sends it over at the end of the month. And so if they review that then after the fact on the first, that makes sense.
And I did want to just touch on one other thing because you guys talked about these overpayments, and a lot of the times that first-time applicants or reapplicants, it takes a long time to get the benefits, no matter how early you start. So you're gonna most likely get what they call a lump sum in the beginning, which was the date that you applied is the date that you can, if you're applicable for that benefit, that's when they'll start paying you from. But then they're paying you 6 months later when they finally decide that you can get this benefit. That means from the date that you applied to that date when they say yes is the amount they should at least pay you for that first check. So you're going to have, for SSI, you're going to have thousands of dollars. So in that first month, you might think, oh no, there's no way I could spend all this. Most likely you have to pay back your bed costs that you owe that facility, but just wanted to make sure if you have a lump sum and you have too much money, Social Security gives you a set amount of time to spend that down, whether it's 6 months or 9 months, depending on the type of benefit. So I don't know if Gail, I don't remember if you guys covered that later on, but I just wanted to make sure that people don't freak out in the first month trying to spend down like $10,000. Which would be a very big challenge. So they do give you time for that to organize that and get that out of the ledger system to make payments where you might need to before they start counting it against you.
Thank you.
Yeah, the best thing you can do is keep a log of any money that you spend on them. You keep a log. You buy them a t-shirt, you buy them shoes, you pay for this, you pay for that. Keep your log, because when they give you that big balance of money, you can say, they had debts to be paid. And so you can go back and that will help to cut it down a lot. Okay? Any other comments, or shall we go on? All right, next slide. Okay. Before you go to Social Security, we're going to help you write together a powerful, concise case for treatment. And you're going to use this paper. It is not an application, but it is a paper that you're going to use for, like, when the police come to your house. If you give it to them, the way it is written, it's so easy to read. They don't have to read paragraphs. It's just right there. Going to Social Security, you give them the information. It helps them to write up a stronger case for treatment. I have, that I am aware of, I've never had anybody present this to Social Security and have them turned down for benefits. You can hire an attorney if you want, but everybody who hires an attorney ends up spending years trying to get their SSI money. Just go straight to Social Security, give them a copy of this, the paper that we're putting together, which will be the history, symptoms, and gravely disabled. It probably will come out to 3 pages. And that helps them to write up a strong case for treatment. And every time your loved one goes in the hospital, you call Social Security and you let them know they're in the hospital. And you give this to the hospital, to the police when they come to pick your loved one up. Any programs you're going to put them in, give it to them. It helps them to have a better understanding of what's going on. Okay, we're going to go to writing the case. Next slide. You're going to write the written case, and basically what I was just saying, you use it to acquire SSI, SSDI, Medi-Cal, VA benefits, whatever. For the police, when they come, when they take them to the hospital, don't assume the police have given that information to the hospital. They didn't. So you go to the emergency room, wherever your loved one is, and you give them another copy of it. If you are, now you can apply for a full service partnership, care court, and AOT. You cannot apply for LPS, but nevertheless, you give it to those people, which helps them to have a better understanding of what's going on with your loved one. The social worker at the jail, you can give it to the social worker at the jail and request that the doctor initiate the LPS conservatorship. Keep in mind, the doctor's treating hundreds of patients. I mean, he doesn't know one from the other. When you give them this paper, they are more inclined to help you to get that LPS conservatorship, which the essence of it is medication, which is what's going to help them to get better. Criminal court, when you go to criminal court, you give it to that. If you go to mental health court, give it to the public defender. Don't give it to the judge. They don't appreciate that. You work through your public defender. All right, next slide. This is the paper you start out, mental health history. If you have a copy of the LPS paper that I send to everybody I talk to, you can copy and paste this, because it's on the internet, to a Word document. It is not a PDF file, so you can make changes. You delete what doesn't apply and add what does. Only 1 page for the mental health and medical history. This has Joe Doe's mental health history. If you copy and paste it, you delete Joe Doe. You only put down your loved one's first name and last name. Nothing else, no birth date, no social security number, nothing else that can identify him. And you start with the last event. The events are hospitalization, incarceration, and homelessness. So what was the last event? Was if the person was hospitalized, you put the date as best you know it. You don't always know everything, to the present. You're only going to put down 4 things: the event, the date as best you know it, the name of the facility or the area if they were homeless, and the diagnosis. There is always a diagnosis. And you underline the diagnosis. If you look to the 3rd one for homeless, exhibiting psychotic behavior. If they've been incarcerated, it might have been exhibiting psychotic behavior. But if you know, if the doctor's giving you a diagnosis, you put that down. Don't write, well, they were 5150 or they were put in the hospital because of so-and-so. You don't do that on this paper. When you get down to the bottom of the paper and you go, geez, I've got so much more to write about, don't. They're looking predominantly at the last 2 to 3 years of information. So at the bottom of the paper, leave a space and put, they've been ill since whatever age. If you want to put, they've had so many other incarcerations, homelessness events, or hospitalizations, you can put that down too. But at the bottom of the page, you're going to put down pertinent information. Any illness that they have that the doctor should know about, high blood pressure, diabetes, heart problems, anything, you put that down. You put down any allergies that they have, allergic to horses, cats, whatever. Any medications they should not take, you put that in red, bold, do not give. Then you also put down the resources they have. If they receive SSI, Medi-Cal, you put that down. Now, you can use the word apply at this time. If you have contacted Social Security because you're trying to get these resources, you can put applied for those resources so that they know you're trying to get them. They do not need to be under the LPS conservatorship to get these resources, but they do need to sign the document until they are under the LPS. Okay? Jim, need to add anything?
No, I thank you.
Okay, next slide.
Thank you.
Next slide.
So
Included at the bottom of the page is, oh, Jim, I'll be quiet. I'm sorry.
you're doing a good job. Keep going if you want. That's fine. Just what you want to do is make sure that you're not only talking about the psychosis and the history that's related to that, but you want to talk about the medical aspect. So down at the bottom of that same form that Gail was just going over with you, be sure to list the medications or any allergies that they might have. You want to.
I'm going to interrupt on that. I would not suggest listing medications that they are on,
Oh,
because a lot of times the doctors have them on medications that are for somebody with a mental health problem,
you're right. Thank you for
not
the
with a
correction.
serious mental illness. And once you list those medications, guess what they're going to get? The same thing. So you're right back in the same boat.
Good correction. Thank you. I appreciate that.
Okay.
So yeah, if they're allergic to Haldol, you want to make sure that you
Yeah.
listen, that don't take that because it caused this medical problem. So also if they have anything such as a heart problem or issue, they need to be aware of that. And also list the resources available such as SSI and Medi-Cal. That lets, if your loved one's hospitalized, that lets them know where to reach out to for funding your loved one's stay in their facility.
I just like to add, when you've applied for, well, just don't tell Social Security that word, but when you've applied for SSI, Medi-Cal, Medicare, these resources open doors for treatment, for better treatment. So you really want to try and get them resources, money that's coming in, and the insurance, the Medi-Cal and Medicare. Okay.
Next slide. So on the back of that same form that Gail was just going over with you, you want to let the doctor know what you're actually observing in your loved one. Are they seeing ghosts, coming around, or are they laughing or smiling for no apparent reason at all? They just all of a sudden bust out laughing. Maybe that's because they're hearing voices in their head. They hear the television talking to them, or that the FBI is telling them or her, him or her what to do. They're delusional. They think they're Christ, or all of these types of things that you're looking at are the types of things that are often observed when somebody's delusional. Make sure that you include those on the back. That gives the doctor, a greater insight into your loved one, because sitting across from somebody, even if they're somewhat delusional, the doctor doesn't really know what's going on or what medications maybe to provide at that time. But if they can see some of the symptomologies, it gives them greater insight for the illness that they're wanting to treat for your loved one. Next slide. Araceli?
That she did the next slide. That was it.
Oh, I'm sorry. Again, these are the same types of behaviors that you can observe. I actually, down here on paranoid thinking, I actually had one of the moms here in Orange County that was just so distraught because her son was actually accusing the mother of molesting him. And she was devastated that her son would say such a thing. You know, it was her son's illness that made him believe that. So I shared with her, you know what, you're in good company. You're not the first mom whose son was saying that he had been or she had been molested by the mother. You know, this is the illness speaking. It's not your loved one. It's the illness, and it happens. And so she was so relieved to hear that. But these are all very important kind of symptomologies that you should be listing on the back of your form that you're going to be providing to them on the mental health history.
Yeah, if I can add, just state what they do. Don't go in, don't write paragraphs. Doctors are not going to read it.
Right.
Just write phrases and don't explain why. If the doctor wants to have more information, they can call you. Good luck. They're not going to call you. They just don't want to talk with you. But the common things that run through are heightened sexual delusions, like Jim mentioned. I mean, we've had guys that are going to have babies the next day. We've had a 65-year-old woman that was going to have a baby. Those are real thoughts to these people, and that's real to them. The heightened racial delusions. I think my favorite is one mom called me and her son hated Black people. She said, I don't get it. He's Black. It doesn't matter. It's heightened sexual delusions against everybody who is not them, or racial delusions against everybody who's not them. They also believe you've stolen their $2 million. When mom told me the other day, oh no, it's not 2 million. I took his 8 million. I said, oh, okay, that's pretty good. But the FBI is chasing them. People are looking at them. These are very real. They're living in a nightmare, and you're trying to wake them up from that nightmare. Don't be surprised when they come out of it. They don't remember any of this. I mean, that's very common. Or if they do, they might remember a little bit. Okay, next slide.
Can I add something?
Yes.
So let me just say this form is critically important. It's been very, very helpful to us. What we have seen, however, sometimes is that when families submit it, they list everything that's here. So please, and then we know that we can't tell what is really happening or not. So please only list the symptoms that are happening for your person. Don't just copy this. List what's happening for your person. It's extremely helpful when you do that. Otherwise, it doesn't have any credence if you just list everything. We know that it was just copied, and it doesn't have the same validity and credence for us.
Thank you, Linda. All right, next slide.
This is also mine. I just wanted to take off a side note is that if you saw me texting, it's because I have a family in crisis right now, and I told them I'd get back to them and gave them a resource. So again, if they're behaving in accordance to his or her paranoid thinking, they're throwing food in the garbage because they think it's poisoned. These are the type of thoughts that people have when they're delusional. I remember there was one family whose loved one had a medication pump that was actually built into his body, and he was able to shut it off because he thought it was poisoning him. And of course, he's putting his health at high risk. And so these are the types of things that you want to let your doctor know about what's going on with your loved ones. But they may have problems understanding and processing information. They can't follow, more than one direction at a time. They can't keep a job, blame everybody else for their problems except for their own self. These are all kinds of symptoms that as Gail said, you want to keep it short. You don't want to go on, rambling on, but keep it succinctly, outlined like it is here. Again, these are just further examples of things that you might find appropriate to be listing on your form on the mental health history.
Mm-hmm. Also, when you're doing this, it's easy to get very stressed and upset because now you're really facing what's going on. Sometimes you've been in denial. Keep a sense of humor. Like one time I was cooking stuffed green peppers. And my son, I heard something in the kitchen. I went in there and he'd taken them out of the oven and he's putting them down the garbage disposal. Well, honestly, I know I'm not that good of a cook, but I didn't think I was quite that bad. So, I mean, just keep a sense of humor and don't get uptight about any of this. This is what they're experiencing when they are very ill. And your goal is to help them come back to reality. All right, next slide. Okay, on that paper, and that paper is going to take you about 3 pages, because the first one is your history, the second and probably part of the third will be the symptoms and characteristics. Do not lie. Whatever you do, don't lie. But these are important things not to put on there at this time. As of January 2026, this is all going to change. So substance abuse will be part of LPS in 2026, but right now it isn't. So do not mention substance abuse when they're in the hospital and you're going for LPS. The hospital has already checked. They know what's in them. Your comment is to them, I am sure because of their mental illness, they are self-medicating. Now, if you're applying for Care Court, AOT, or another program, you can mention substance abuse because they kind of need to know for treating them. But if you tell the hospital about it right now, their attitude is, this is a substance abuse program, so we're going to discharge the patient. And that's what you don't want. So you just say, I'm sure because of their mental illness, they are self-medicating. End of topic. Okay, don't mention violence. If now with AOT, you can kind of tell them, but don't go, oh, well, they did terrible things, because you state they are highly aggressive towards violence. Limits where they can go for treatment because they become a liability, an insurance liability for the facilities they're trying to put them in. So you have to be a little bit cautious on that. Do not say they can come home. Presently, to be conserved, and we're talking about LPS now, you have to have a serious mental illness diagnosis and be considered gravely disabled. Gravely disabled only applies to food, shelter, and clothes, nothing else. They don't care how crazy a person is. And I'm sorry, I'm not PC, but they haven't given me another term to use other than crazy. So I still use it. But they do not, if you say they can come home, and the hospitals will tell you, we're going to discharge them at 3 o'clock in the afternoon. Will you be picking them up? And you say, well, I want them under the LPS conservatorship. Well, ma'am, they don't qualify. So will you be picking them up? Yes, I will. The hospital's correct, because the addition on that statement is if someone else is willing to provide their food, clothing, and shelter, they are not considered gravely disabled. If you don't have gravely disabled and a diagnosis together, you can't get the LPS, which is an involuntary mental health treatment. So you want to say they cannot come home. Now, if it were my kid, I would say that, but I'd probably be sitting in the parking lot in case they did come out to bring them back home, because when they're home, I can get them back in the hospital a lot easier. Okay, next slide.
Gail, I have an acute upset stomach. Can you carry on for me just for a little bit? I want to go take some Pepto-Bismol and I'll be right back.
Jim, you have gone through so much today and the last forever.
Okay, well, I'll be right back.
Oh, no problem. Okay. Common symptoms, which I mentioned earlier, the heightened sexual delusion, the racial against everyone who's not them, FBI is changing them. And oh, I love this one. They're not ill, but you are. And I mean, that gets so real to them. I mean, my son took me to the hospital to have me admitted, and, they admitted him, but still, and as far as I was concerned, a little R&R for the weekend wouldn't have been so bad, except I did not want to be his roommate. So next slide. Gravely disabled. This is the definition. It refers to food, clothing, shelter, nothing else. A person with a serious mental illness cannot, because of their illness, provide for their food, clothing, or shelter. But if someone else can provide for their food, clothing, and shelter in a safe manner, they will not be considered gravely disabled. That's today. January 26th, a lot of this is going to change. And I think next time when we talk, we're going to try and put down some of the new things that are going to be taking place. So you'll be prepared for it. And I'll just give you one incident. One kid was in the hospital, psych hospital, very intelligent. They're smart people. The brain works. It's that frontal lobe that processes information is a problem. But he had everybody, he wrote out a paper and he had all the patients in there sign that they were going to take care of him. So when he went to court, he gave that to the judge. The judge went over everyone. And where did you meet this person? They were in the psych hospital. And who do they live with? Well, their family. Okay. And then went on through all of them and, gave him the respect for what he did, but did not, honor these people are going to take care of them. So they're very clever. They're very smart. Next one. The shelter. This is written down pretty much on everything, but the shelter, they may not come and live at home. They have no place to live safely. And you can copy this part verbatim. No problem with that. But refer to food, shelter, and clothing as a safe situation. We had a situation where a fellow was at court and he says, Your Honor, I can provide for my food, shelter, and clothing. I can get a tent and go live on such and such street. I can eat all the food. I can eat 5 times a day at the food banks, and all the clothes I want, I can get that from Salvation Army. The judge had nothing that he could hang his hat on to give him the LPS, because he was providing, not the way we would like it, but he was providing for his food, clothing, and shelter. Now, if a family had been there or someone else and said, yes, Your Honor, he could do the shelter, but when he's out on the streets, he's either victimizing people or he's being victimized himself. The food, he's lost significant weight from not eating, or he's compulsive eating and putting on excessive weight. Either one would cover it. And you only need one because the word is food, clothing, or shelter, but we try to hit all 3. Clothing, he takes his clothes off at inappropriate times and places, or he wears clothes for excessive periods of time, or he dresses inappropriate for the weather. Any one of those will cover it. And they don't do anything 24/7. So when they do this stuff, you put this down. By the way, when you're doing those symptoms, don't put at this date he did this, or don't put time frames. He was at a facility for 2 weeks and then he left. Guess where he's going? Right back to that facility. So you don't want to put time frames or explain anything. The other, which is not gravely disabled, but because they have allowed the person's history to be taken into account for their evaluation, this one you can add. They have no insight into their illness, and therefore they are non-compliant with medication and treatment. And that covers pretty much everything. All right, next one. Next slide. Decide with your loved one, and this is something you have to do too, because this is very stressful, and you hear a lot of myths that are floating around that aren't true. But which direction would be the best for your loved one? If they have insight into their illness and they're in touch with reality, the recovery model, full service partnership, would be a pretty darn good program. They come to your house, they talk with them, they work with them on the medication. They would have resources to a psychiatrist, a therapist, a social worker, caseworker, whatever they need. Care Court, which is also, it's just start. I'm drinking too much Coke. They're very good about working with your loved one, trying to engage them, seeing whatever they need, whatever their needs are. If they need a place to live, they can help them with that. they can help them get their medicine, get a treatment person or whatever. If they are the kind of person who they're not going to accept anything, then care court may not be the best place for them. Assisted outpatient treatment this is kind of up the ladder for the quality of treatment. Assisted outpatient treatment is really good, and Linda Boyd and Venice are going to talk about these two programs where they come out to the person, they talk with them, they'll meet them in the hospital, even at the jail, and they will work with them. And some of the success rates, because assisted outpatient treatment's been around a lot longer, but these are voluntary programs and they cannot force medications. But the people they hire and they train are pretty good at trying to convince them to take medications. So they do have some pretty good success. The highest level would be the involuntary, the LPS conservatorship. If they have no insight in their illness, if they have no touch with reality, this is a better way to go, because their brain has big gaps of gray matter that's missing, and they need to have the medication to help heal the brain. Without that, you may as well talk to the brick wall and try to tell that brick wall to step over a foot. It's not going to do it. And these people, you can't convince. They do not have that ability, reasoning ability. And their paranoia most likely scares them from everything. So decide the treatment direction that you think your loved one would go for, and you can call any one of these programs. The first three you can apply for and give them that history, symptoms, and gravely disabled. That really helps. The fourth one, when they're in the hospital, it is a treating doctor that initiates the LPS. And if they're in jail, it's a treating doctor that initiates the LPS. Now, with that said, care court and assisted outpatient treatment are going to be changing that if they haven't already, and gradually push them over to an LPS probably after the first of the year. But I'm not going to say any more because I probably just said everything all wrong, and I'm going to let Venice and Linda deal with that. Next slide. Hospitalizations. This is the process when you're getting your loved one hospitalized. And this is important. If your loved one is harm to self, harm to others, or a flight risk, they'll take off. Then when you call the police, you ask them to bring an evaluator, okay? Do not wait for your loved one to hurt someone. You don't want that to happen. If they're threatening, if they're getting highly aggressive, call the police and get them in there. Now, we're having trouble with the police right now because they are at the point where they're saying, we're not coming out on any more 5150s, or we're not going to put hands on. If the person doesn't want to get on the gurney to go to the hospital, hey, we're not going to do it. And this is a problem. And I suspect, I may be wrong, but I suspect because they pick people up 10, 15, even 20 times, and the hospitals just release it. The hospitals don't do their job of treating the person to help them to get on the road to recovery. That is our goal, getting them on the road to recovery so they can get their life back as close as it was before they got sick. And I will tell you, there are a lot of doctors, psychiatrists, lawyers who have a schizophrenia diagnosis. But I don't think if you're going to see your doctor and he's going to operate on you tomorrow, that he's going to say, oh, by the way, I want you to know I do have a schizophrenia diagnosis. You'd be getting off that gurney and going someplace else. But they do, and they can live normal, regular lives with the right medication and the right treatment. So, you know, it's just what it is. Now, if your loved one is gravely disabled, where they maybe don't get off their bed, they can't leave the house, they're losing a lot of weight, you don't want them to lose a lot of weight because now it affects all their organs, and that is bad. You can call the access team and ask them to send the police with them. And they can come, and the police will keep them from, taking off, or that's what they used to do. I'm not so sure they're going to do that anymore, but still. But the evaluation team can help you get them in the hospital so you can get them treatment. Now, on the back of that third page that you write on the history, symptoms, and gravely disabled, write 3 open-ended questions, because as you know, and you've seen it happen, somebody comes in, they go to see the doctor says, how are you doing? Oh, doctor, I'm doing fine, but my mom's really got a problem, or my dad, or whatever. So you write 3 open-ended questions that can show them the state of mind they're in. For instance, you don't ask yes, no questions. I understand that your mother stole your $2 million. How can we help you with that problem? They are going to open up and tell, because they're going to believe that they believe what they're saying. Or I understand the FBI's been following you. How can we help you with that problem? Questions like that, but put 3. So if one doesn't work, hey, try another, and then try the third. So when they're telling them how great they are, then basically when they ask these questions, they will get a better side of it. All right, next slide. Hospitalization. When they go to the hospital on a 5150, also known as a 3-day hold, or the 14-day hold. It's not known as a 14-day hold. That's a mistake. The 5250 is your 14-day hold. But when they go to the hospital on the 5150, that 3 days is what they evaluate them at. Be sure to give that history, symptoms, and gravely disabled to the social worker to give to the doctor. It will help the doctor to do a better diagnosis and to be able to keep them for 14 days, for the next 14 days, which is a 5250. Now, within that 14 days, this is a process how it works. Within the first 4 days of that, used to be working days, but they count weekends as working days, of that 14-day hold, they have to have a probable cause hearing. It's also known as a certification hearing. And that will determine whether they can keep them for the full 14 days. Hospitals don't keep them for 14 days. They will discharge them at day 11 or 12, unless they're going to put them on an additional 30-day extensive hold. It is after that probable or certification hearing that if the doctor is going to initiate the LPS conservatorship, they will do it at that time. Now, if they don't, but they're going to put them on an additional 30 days, then within the first 5 working days of, or 5 days of that 30-day hold, the doctor can initiate the LPS conservatorship. Now, this is not the law, but it's the public guardian has to have time to do evaluations. And they are on a strict time limit that if they can't get things done, like you're doing a 14-day hold and they initiate the LPS the last day of the 14-day hold, they had to do certain things prior to that, and you're limiting what they can do. And if they can't complete it, then the hospital has to discharge your loved one. So these are the things that they do. Now, when they go on the temporary conservatorship, the doctors initiated the LPS conservatorship with the public guardian's office. The public guardian accepts it. Now they are under a temporary conservatorship. Almost all the information that you need, you can get from the public guardian. It is a public guardian that if you choose to be the conservatorship, you tell the public guardian that basically you want to be the conservator. They will evaluate you to know that you are of sound mind, And chances are they're going to say, yeah, you can be the conservator, because each person's handling 50 to 75 patients. That's a pretty heavy caseload. So if you let them know you want to be conservator, that's the time to do it. And we're going to talk about 2 types of conservatorship under the LPS, but we'll do that later. Okay. James, did you want to say something? I just saw your chat. Okay, you're going to cover that? Okay.
Yeah, I'll just do it in the chat and then we'll talk about it when I come on.
Okay, sounds good. Okay. Next hospital. Oh, by the way, not every county has that additional 30-day hold. San Bernardino doesn't. Okay, next slide.
Yeah, I can pick it up if you like.
Okay, go for it.
Okay. So in acquiring the LPS conservatorship, the treating doctor in the hospital or jail can initiate the LPS conservatorship. This is not law, but it's practice. So generally, a person must be in the hospital or jail. So a conservatorship basically has to be a process where there's a treating or attending doctor. Again, it's usually a designated hospital, not just a normal hospital, but a hospital that's actually signed up with the county to be in receivership of somebody that needs a mental health assessment. And that doctor can then, after assessing the person and determines that that particular individual needs to be placed onto a conservatorship, they then can fill out the necessary forms. Those are sent over to the county council. At least that's how it's done here in Orange County. County council is a legal team basically for the county, and then they in turn forward that over to the public guardian's office, and it goes forward from there. So just remember that if your loved one is in the jail and there's a significant charge against them that's going to have them held in jail for a period of time, and they're suffering from a mental health condition as well, that initiation of a conservatorship is something that can be done right inside the hospital, or excuse me, jail itself. So either of those settings is where that can take place by a doctor.
Okay, if I can say something, James, and you might want to add on this. When the doctor initiates it, if they initiate it in Los Angeles with the public guardian's office, am I correct, James? And then the public guardian contacts county council?
So I want to clear up just the lingo so that we don't confuse anyone at the hospital.
Okay.
A treating doctor, a designated person who can refer to the public guardian for LPS conservatorship, it would be the more correct term there. They can't initiate conservatorship. Only the conservatorship investigator, which is the public guardian in every county, can initiate a LPS conservatorship investigation. So just so that if you're talking to, the doctor or whoever at the hospital, they may go back and forth with you on this term. So the right term would be, is it appropriate to send the referral to the public guardian for a LPS conservatorship? And then Gail, the process, I will go over it a little bit in my presentation, but basically the process is we receive a referral. We vet it if it's appropriate or not for various things. I'll go over that in our slides. But after that vetting, an investigation will start. Typically, what happens when we actually accept the investigation is we will let county council know that we want to file for, one is a hearing date because we have 30 days to investigate now, or less than usually, right? So we ask for a hearing date to hear the permanent LPS conservatorship matter, and at the same time, we will file for that temporary conservatorship to ensure that your loved one remains in that protected setting until we can finish our investigation. So those are the things that we send over to our county council so that they can interact with the court to, one, get the temporary conservatorship, and two, file for that permanent hearing date so that we can have a hearing on the LPS permanent matter.
Okay.
Hopefully that makes sense.
Yeah, it does. Thank you for correcting that. We've been using initiate forever. nobody's ever said anything. So, but it's the doctor refers and then the public guardian initiates it with county council. Is that correct?
Yeah, so county council is just the attorney for the public guardian, which means, you
Right.
know, when you're doing legal things, you don't have lay people do those things. So county council, the only function of county council is to act as our attorney for filings, petitions, hearings, etc. So they have no role in any decision making in
Right.
regards to the conservatorship. They're just that intermediary, just like you as a private conservator may utilize a private attorney when you have a conservatorship and you want to do a reappointment or anything like that.
Okay, sounds good. Thank you. Next slide.
Yeah.
LPS via the hospital. And we're just redundant on this now. When you give your written case to the treating doctor, that if you should have 3 pages, history, about 1.5 page of the symptoms, and then the gravely disabled, and you can plagiarize that gravely disabled, but delete what does not apply. Okay, request the doctor refer the LPS conservatorship, and but they usually do that after the probable cause hearing, which is at 4 days when they're on the 14-day hold. So from when they go to the hospital to when they have the probable cause hearing, or depending on what hospital, they call it different terms, the certification, it'll be about 7 days from when they first enter the hospital. Okay, next slide. Via the jail. Actually, now it tends to be in Los Angeles easier to get the LPS through the treating doctor at the jail. But be sure to give him that history, symptoms, and gravely disabled. He sees hundreds of people. He doesn't know one from the other, but that paper will help him to look at your loved one and then be able to write it up a little bit better. So you request the treating doctor at the jail to refer the LPS conservatorship and give them that written case, and then request the public defender. Ask when they go to criminal court, they're going to go to criminal court and you'll probably have the arraignment first. Take your history, symptoms, and gravely disabled to the court. Ask the bailiff, who is the public defender for your loved one. Give them a copy of that and ask that they get the mental health liaison involved in the case. The mental health liaison opens doors for treatment. So you definitely want them involved in the case. You can also get them in a jail diversion program, most likely. It depends on the crime that they did. And basically, the jail diversion is voluntary, but they do a pretty good job coercing them into doing it. And it runs about 18 months, give or take. If they're under the LPS, I consider the LPS like your insurance policy, because the LPS, the essence of it is to mandate medication. So if they go off the medication, you can get them back in the hospital and right back on their medication. So they're not going to, go down the tubes a little bit. If they don't have the LPS, if they're not under the LPS, and they've agreed to go on the jail diversion program, but then they, get off the wagon or whatever, then it all goes down and it can really mess up their whole court things. Usually after the jail diversion, if they've completed that, depending on what it is, they can either dismiss it as if it never happened or lower it down to something so it's not such a big deal. So but get that mental health liaison involved in the case. Each courthouse has one mental health liaison involved. So you want to find out who that is and be in touch with them and give them the history, symptoms, and gravely disabled, as well as your public defender. Okay, next slide.
Oh, James, you can unmute.
Oh, okay. So, Gail, before you move on, because this you hit the nail on the head, where in Los Angeles County, at least, and I've worked both in Orange and LA County doing the same role. So there's a bit of a difference here if you live across the border in Orange County, where they prosecute crimes and how they do jail diversions and what we would call an IST. So I just want to be, this may be a little bit technical, but just so that everyone's aware of the terminology. If your loved one gets picked up on a charge, and it's either a misdemeanor or a felony, where like their mental health obviously was involved in the commitment of the crime, and then during the time that they're committed and they're going to be arraigned and they're doing the trial setting and all of that, most likely the parties that are involved will realize this person is not able to competently be involved in their own defense, right? That's one of the things that's really important in our country for our constitutional rights is for us to be afforded the right to, have our own defense and be able to have attorneys represent us. But if you can't assist in that, if you cannot assist in that, what they're going to do most likely in court is say that you are incompetent to stand trial. I think this is where, Gail, your communication about making sure everyone understands the person's mental health history and current symptoms, because in jail, they may not always catch that. So if any of you guys have loved ones that kind of cross their path through the criminal justice system, that's kind of typically how it works is that if you have a misdemeanor, and most likely if you are deemed incompetent to stand trial, you're gonna be cycled through that diversion program, like Gail mentioned. And the diversion program is run through the the Office of Diversion. It's a specific office, especially to LA County. They have many placements and treatment settings. So, I recommend that highly, that if diversion does come up, obviously, that is an option that you want to go. I just want to be clear that typically what happens for misdemeanors is if you fail diversion, potentially the court can refer you back to either AOT care or an LPS conservatorship. So typically they don't happen concurrently. They want you to try one program first, and if it doesn't work out, then there is the safety net of either AOT care or an LPS conservatorship. And then at the conclusion of that diversion, obviously, on a misdemeanor, they would probably dismiss the charges once you say that you're going to go into diversion. If it's a felony, it's going to be a little bit different in that they're going to, because it's a more serious crime, they may send you to either the state hospital or some other state hospital type setting where you get intensive treatment so that you can be competent to stand trial. Often, a lot of our loved ones will not make it to that competency to stand trial, and they'll get returned back to the county. And then that's where the competency court will now decide whether they're going to go to some other program. A lot of the felonies they cannot go into a diversion program. So you may be looking to have them go through a diversion program, but there's like 8 or 9 crimes that are not divertible at all. So those are kind of details. I mean, if you reach out to our office, we can go over those details if you guys have any, specific loved ones that are in that situation. But when you're talking about the mental health situation and their grave disability, that's the process when someone is jailed. Is first they need to be deemed incompetent to stand trial. For them to have any chance of being referred to the Office of the Public Guardian for conservatorship. People don't typically sit in a criminal setting, in a criminal jail, and we get direct LPS conservatorship evaluations because they do have to go through the other options. So I just want to make sure I let you guys know that so that there's not frustration about how come they're not sending it directly to the public guardian. There's all these other kind of, things that are in place to kind of alleviate people's mental health, hopefully, before it gets to an LPS conservatorship.
Right. Okay. But just keep in mind when you are dealing with the jail, there can be 3 separate cases. Your criminal case that they're looking for something, did they or did not do the crime? The competency, are they competent to understand what's going on to help in their own defense? And if they do LPS, then that's mental health. Those are three different settings, and they're looking for three different things. Don't get them mixed up. Okay, next, and we need to move along a little bit faster. Welfare and Institutions Code 5008.2. Oh, wow, what happened there? The law requires that all healthcare providers, they must, shall is the legal term, I use the common term, must take your information, and the historical course of a person must be taken into account for treatment. That's why we do that history. That paper is very important. The court stated that harm may be through neglect or inability to care for oneself. Therefore, if they lack the provisional sense to care for themselves due to their mental illness, they meet the criteria for the 5150. Unfortunately, I hate to say it, but a lot of people don't do their jobs. They just pass the buck. And consequently, we're left with struggling to get treatment for our loved ones. In Los Angeles, we are lucky. We have some really good people. Venice, James, Linda Boyd, she just amazes me, the things she's done, miracles as far as I'm concerned. But okay, next slide. The criteria for the LPS, we mentioned earlier, they have to have a serious mental illness and be considered gravely disabled. One without the other is not LPS. Now that will change January 1st. And if the person doesn't tend to have insight into their illness and they're non-compliant with treatment and medication, in my opinion, they should be under the LPS, because if they can't gain reasoning ability, it's very hard to get them with medication, and they need that for the recovery, the healing of their brain. All right, next slide. Jim?
So, yes. So what is actually deemed to be a serious mental illness? Oftentimes you hear that written as SMI. It's your debilitating illnesses such as bipolar, schizophrenia, schizoaffective disorder, which is kind of a combination of depression and delusional aspects. If they have clinical depression, obsessive compulsive disorder, or chronic alcoholism, those are all deemed as being a serious mental illness. Next slide. So the types of LPS conservatorship, well, there's a conservatorship of the person, there's a conservatorship of the estate. So what is that about? A conservatorship of the person, the treating doctor in the hospital initiates this conservatorship with the public guardian. The public guardian petitions the court for the temporary LPS conservatorship and investigates the need for permanent conservatorship. That's of the person. LPS conservatorship of the estate. Now we're looking at somebody like maybe Britney Spears. It goes on to say that you request a conservatorship of the estate through the public guardian's office to ask the court, so that you have, like Britney Spears, the father then was assigned by the courts to oversee and protect the monies. Whether or not that was the case with Britney Spears, there's all a controversy, don't want to go there, but that basically, if a person is running a business, has sufficient funds and so forth that need to be protected, then that's considered to be something that needs to be protected under a conservatorship of the estate. And so the person could then be the conservator of both the person and the estate both. Next slide. For older people who do not have a mental illness, they could be put onto what's called a probate conservatorship. The laws are different for probate, but nonetheless, it is a type of conservatorship that will look out for their well-being and care. It can also be for younger people with other illnesses such as autism, brain damage, stroke, or any brain illness that is not mental illness. So they're two different conservatorships. Both of them are focusing on caring for the individual to make sure that they're safe and so forth. But the laws around them are different. And what's involved is significantly different. For example, a probate conservatorship can be initiated by the parent of a loved one. It doesn't have to be initiated by a attorney. Also, that a probate conservatorship is for life. Once it's established, then you have somebody like perhaps has Down syndrome. They could be placed under a probate conservatorship, and so for the remainder of their life, they would be under the care of that conservatorship. Unlike a mental health conservatorship, which is 1 year in duration only, that has to be renewed each and every year after that is gone through a review process. Next slide.
I just want to add one thing on this. If you're hiring an attorney to help you get the conservatorship, the attorneys, and this is just the feedback that I get from many people, they've paid $10,000, $40,000, whatever for the attorney to get the conservatorship. The attorney, I would say 99% of the time, go for the probate conservatorship. When they get to court, the judge says, you're in the wrong venue. This is for mental health, which would be for an LPS conservatorship. So they dismiss the case, and the attorney just says, I don't know why they dismissed it or whatever, but there goes your money. If you're doing a probate conservatorship, you can hire an attorney. That's not a problem. If you're doing an LPS conservatorship, unless that attorney knows what they're doing, because it is not the attorney who can refer to county council for that LPS conservatorship. It's only certified people, which would be the hospital, the treating doctor, and certain other people who can actually do a referral or a request that the doctor initiate the LPS conservatorship. So I don't suggest you hire an attorney to help you get it. Now, when you go to court, the attorneys are very good at the mental health court for LPS. They know what they're doing, they're very knowledgeable, and they understand LPS conservatorship. And they're free. I like free. And when you get a conservatorship asked to have an attorney assigned to you for the year, they too are free. Okay. Sorry, Jim, go ahead.
No apologies needed. We've covered that. Let's move on. Next slide. There we go. So being on a conservatorship, an LPS conservatorship, does mean actually for both, but there are rights that individual actually will lose, and so they lose the right to refuse medication. Unfortunately, some people on an LPS conservatorship don't seem to understand that, and I don't know. In my conservative's case, they don't seem to understand that, but I do my best to try to get that across to them. So that's really the essence of a LPS conservatorship, is that the courts don't want them to go off their medications, and they won't allow them to go off medications. You can't force somebody to take medication, at some time, unless they are in a designated hospital, and then that medication can be provided, if necessary, by force, by one means or another, whether it's oral or injection. But those are types of losses. The other rights that can be terminated, but that are also something that can be reinstated, would be the right to enter into contracts. So if you have your loved one on a conservatorship, they can, if they go out and they sign a contract for something, that's not a valid contract because they are on conservatorship. They lose the right to drive a car. They also lose the right to possess a gun. Again, these are things that at a later point in time, even while they're still, I don't know about the gun, but while they're driving a car, once they've really stabilized, the right to drive a car can be reinstated through a process that involves the courts. Next slide. Gail?
Okay, I'm going to go quickly because we need to hurry,
Okay.
so other people can talk. The rights of the conservatorship, of the conservator. Your right as a conservator is to approve or disapprove treatment, placement, And medication. This means you can be working directly with the doctor on the medication, but usually you work through the social workers. But if you need to talk with that doctor, that is your right. Okay, next slide. Who should be the conservator? This is something to think about. If the public guardian is a conservator, they're able to place a person in a state-approved facility, and there's a lot less stress for the family member. The negative is you have less involvement with recovery, and you have no control for medication. And I hate to say it, but many of these doctors, psychiatrists, instead of working to help to get your loved one on the road to recovery, they'll give them a smorgasbord of medications. Shoot, you want to tell me which one's going to work? Because I would have no idea. Or they give them inappropriate medications for their illness. I mean, and I'm sharing all the feedback that I've gotten over 25 years. Medications that work for people that have a mental health problem, and they're medications that work for people who have a serious mental illness. It is trial and error to figure out which one it is. And when the doctors start telling you that's the best you're going to get, and you're going, oh my goodness, this is terrible, don't buy into it. Fight to get something better for your loved one. Okay, be sure if the public guardian is a conservator, you work nicely with that public guardian. Keep in mind, they're dealing with about 50 to 75 people. So don't get on the phone and start just blabbing away. They don't have the time. Email them and then let them get back to you. All right, next slide. Should you be the conservator? The pros of being a conservator, is you have direct contact with the doctor when you need it. And you can reject inappropriate treatment facilities, medications, and treatment places. That's a biggie because some of those places are not set up. You know your loved one better than anybody else. So you tour those facilities, and if it not appropriate, you can say no. You can say no to medications, but if you start being arrogant, the doctor can take you and have you basically taken off as conservator and give it back to the public guardian. But likewise, you can get another doctor. All right, the negative is your conservator manipulates you. That's a very common thing. And you have to be strong and say no and set limits. The hospital will try to push you around and discharge the patient to a facility that's not appropriate level for the treatment needed for their recovery. Tomorrow, we're going to go into a lot of this and tell you what to do. But for now, we're going to move on. Next slide. The normal process is your 5150, your 72-hour hold, which is the 5150, the 14-day hold, and the 30-day hold, or the TCON, which is when they're trying to get the conservatorship. Okay, and I think James is going to go through a lot of this. Next slide. The court hearing. The patient is assigned a public defender. And a lot of parents say, that's the meanest person. They're not there for you. That public defender is there to do what your loved one wants them to do, which is usually, I don't want that conservatorship. So they're going to give you a hard time. The patient can request a court hearing, which is the judge, or a jury trial, which is convincing 12 people to say that they need treatment. So those are the things that the patient has on their side. All right, next slide. The department, mental health department, A, and now I think they have B. Linda's going to talk about this. Superior Court Department A is in Norwalk, and we have 3 judges, I understand. Linda told me about that. Judge Heron and Gilbertson, who I know they're both excellent, but there's a 3rd one now. So that's the address if you're doing the conservatorship hearing. Next slide.
I don't believe there's a 3rd judge. I think it's just Renee Gilbertson and Judge Heron. James may know better if they've added something recently.
Oh, okay. All right. Jim?
Okay, after the LPS is granted, the hospital should hold the patient until a proper facility is appropriate for the patient to be cared for is located. An intensive care division should be requested for an evaluation of the patient for placement, and the level of care is determined by a clinical recommendation for an IMD, a step down, now called the ERH, or whether it be a board and care, sober living, or an outpatient facility. So you have to determine what type of facility would be most appropriate. That's a clinical recommendation. And then it would be up to the conservator to go out and locate that in a case of a board and care, sober living, and so forth.
Yeah, because the conservator doesn't go and locate the facility. The intensive care division does that for you. And then they give you a list that you can go and say, you know, what your opinions are.
Okay. Next slide. Suggestions for recovery. Remember what your loved one was like prior to their illness. And that really is, after all, what you're trying to do is you're trying to find the right programs, the right medications, the right level of medications that will best help them regain, you know, their clarity of mind and you know, feel and be able to react as they did prior to their mental illness. So you need to be very, very familiar with medications. You need to look at the type of therapy that's going to be utilized in the care, whether it's cognitive and so forth. And do they have, are they co-occurring? I mean, do they also have, in addition to their mental illness, an addiction issue? And so what sort of treatment plans might you want to look for? Here in Orange County, we can contact any of the behavioral health clinics that are around, and they can certainly direct you to various locations for that treatment.
Yeah. Jim, we have 2 more minutes.
Okay. I'm done. Next slide. Yeah.
Oh, to educate yourself and help yourself, be sure to take that free family to family 12-week class that, well, I think it's 8-week now, that NAMI offers, depending on which one they offer, and some of them are on Zoom. Join NAMI, get involved. That is really important. Okay, next slide. We're going fast now. Be sure, and this is important, keep 2 journals, one for your loved one and one for everybody you speak with. Your journal for your loved one has their medications. When you're talking to them and they're telling you something, don't correct what they are saying. This is your insight into how their mind is working. Now you can say, I'm sorry you feel that way. That's got to make you feel uncomfortable or something like that. But at night, write down what they said. That way you can follow their progress. And the second journal is everybody you speak with, including if you call me, put it down. But you don't have to write everything. Just put LPS info or something, because it's all on that paper. But that is important, their contact and everything, because you will get a lot of things that aren't true. And when you get that, and I'm hearing hospitals say who are LPS certified, we don't do LPSs here. We report them. Okay, keep a sense of humor. If you don't do that, you're sunk. So keep a sense of humor. Remember, this is their illness that has hijacked their brain, and you're trying to get their brain back. Next slide. Next slide. These are just homeless people on the streets here. Next slide. Jim?
So remember that you're really the one that was going to be looking out for your loved one. And remember, you're the brother's keeper, you might say. Please help us to continue having these sort of classes here at NAMI Urban Los Angeles, and donate if you can, but only if you're in a position to do so. If you're, for heaven's sakes, if you're on Social Security or a pension with the cost of days living, and it's a hardship for you to donate, please don't. But if you're in a position where you can donate, please make go up onto the NAMI Urban Los Angeles website and make a donation. You can earmark that donation for the LPS class, and that will pay for the expenses that are involved with the NAMI setup here over the weekends. And this is, you can mail it into the address you see on the screen, or as I say, just go up on the internet and you can locate them and make a donation online.
Okay,
slide.
questions. We're going to do questions at the end of all the presentations. So if you can hold your questions to that time, it would be easier. And half the time you're going to get the answers if you're listening to what they're saying, to what everybody's saying. Okay, I think it's James.
Thanks, Gail. And I'm gonna go over mine fairly quickly. And again, I believe the slides will be sent out to everyone, right, Gail?
I think so.
Okay.
They're added to our website. They're not.
Oh, okay, perfect. So then I just want to make sure like some of those details you can look back on. And I'm going to try to just hit on some of the points that you guys didn't drill down into details because you're saving it for me. So we'll go over these kind of quickly. Let's go on to the next slide. My name is James Kwan. I'm the Deputy Director at the Office of the Public Guardian here in Los Angeles County. I think we kind of covered what is conservatorship. But the conservatorship is not a person or their situation. The conservatorship is actually the legal proceeding. So when we're talking about a conservatorship, that's what that is. And specific to LPS, we don't conserve people. I know that people have various concerns and very legitimate concerns about their loved one. But when you're thinking about a 5150 and then you're moving on to probably you're looking for a conservatorship because you want a little bit of long-term stability for your loved one. Number one, the number one thing you have to think about is there an actual treatment modality that can help my person that exists currently today, right? So I know, Jim, you touched a little bit for probate. There might be a TBI or other things that are neurocognitive. We don't have treatments for most neurocognitive disorders today. Not most, all, really, right? Whether it's TBI, there's treatment, but there's not things that set you back to prior to that particular TBI or neurocognitive disorder situation. So when you're talking about your loved one's mental health, we want to make sure that you guys understand as well. The purpose of the conservatorship is solely to provide individualized treatment, supervision, and placement of that person, and then the estate portion, as Gail and Jim kind of mentioned. And the other thing that's in code is that the care plan that's developed in conjunction with the clinical team and the conservator, the purpose of that care plan is not necessarily to bring somebody to 100% to where they were before all the mental health issues may have began, right? Obviously, that's probably your goal. That should be all our goals for all the loved ones in our lives. But for the purposes of the conservatorship, the goal that the law has set is to make sure that person no longer demonstrates their grave disability. So the behavioral manifestations of their grave disability, meaning right now, currently, their ability to get food, clothing, and shelter due to their mental health. The goal of the plan is to alleviate that first and foremost. So I kind of wanted to set that expectation so that families are not disappointed when, they're not fully there yet. They can't get off conservatorship. However, the conservatorship is a legal proceeding, and most likely, if someone can make viable plans for the food, clothing, and shelter, they will win that next case, the reappointment or whatever, rehearing the next hearing. So I do want to kind of level set for everyone the expectations, because LPS conservatorship is also not a silver bullet for mental health, right? There's a conjunction of a billion different things that need to go right for all of us to maintain our mental health. So I did want to say that there are times we get feedback. It's like, they were on a conservatorship. What happened? Some people, they end up becoming not gravely disabled, but their mental health is not 100% there where they find that stability after the fact. This is an unfortunate reality of people still being able to make their choices afterwards. So I did want to kind of lay that out there. It is a tough truth to kind of speak, but being in the business for almost 15, 20 years, that is something that does happen under the system. So that's what a conservatorship is. Moving on to the next slide, we're going to talk about types of conservatorship. So I want to make sure, most of what we've been talking about, we're talking about LPS. If we do end up talking probate, again, LPS is grave disability, right? And we talked about the definition of grave disability, and we'll touch on it a little bit more. Probate is solely based on a person with a neurocognitive disorder where they do not have capacity to fend for themselves. Capacity is actually a much tougher bar than grave disability. It may not sound like that, but people who are on LPS conservatorship can still retain their capacity for a lot of things. Probate, oftentimes these are people with Alzheimer's dementia or other types of dementia where one, there is not a lot of hope in today's medical world for them to regain their pre-disease capacity. So it will only get worse, meaning an LPS wouldn't make sense because there's no treatment modality for them to improve. And then that this disease has taken root so deep that there is not ability for that person to even make any kind of informed decisions for anything. Not even like, what do I want to eat today? Oftentimes the capacity goes that deep. There is a third type of conservatorship because Jim touched on people who may have developmental disabilities. This is just a personal take, but most of the time, people who have DD, whether it's you're on the spectrum, autism, Asperger's, TBI, or any of the other what you think more traditional developmental disabilities like Down syndrome and stuff like that. Those are services typically served by the regional center. And then if for some reason families who have loved ones that are getting services through the regional center, then a limited conservatorship may be more appropriate. We typically, unless there are, mental health or serious capacity issues, we don't recommend that they enter into this system because the regional center actually is funded with a lot of money, and they have appropriate placements and people who are trained specifically for that type of work. You do not want to have someone who has a developmental disability or like Down syndrome, and then they're in an LPS facility. That would not be great for anybody involved in that process. So again, if people do have questions on that, my contact info is there. Please feel free to shoot me an email for specific situations. Moving forward. So again, probate conservatorship, you guys touch on it really well. Is typically for this type of population. And again, anyone can become the probate conservator directly, right? The probate process is built into probate code, which governs not just probate conservatorship, but decedent estates, trusts, and etc. It's a very big code, but those are things that families can do directly. However, the public guardians we are the last resort investigator and the last resort conservator for people who have capacity issues. Again, if you're not quite sure if you're in a situation where someone has capacity or not, the biggest demarcation again would be, are they dealing with a serious mental illness or do they have some other comorbidity like Alzheimer's dementia, a traumatic brain injury, other things where it's like more neurocognitive rather than psychiatric would be the first thing. And then the second thing would be, is there a chance of recovery through current treatment modalities? That would be another big trigger in that, again, we do not want to be involuntarily committing people on an LPS conservatorship, and there's no goal, a plan to make them better, right? Probate conservatorship, a lot of it is for the protection of that person, and is typically an elderly person who's in their 80s, 90s to protect them and their estates. So it's a very different bailiwick than LPS. Moving on to the next slide. The other thing is, anyone can refer, not just families, but almost any party can refer. If you go on our website, you'll see how you can initiate the probate process. So that one is very straightforward. A lot of people who you think as mandated reporters are also people who should be referring when they see signs of neglect or abuse, especially with our elderly population. Moving on to the next one. Again, just big difference because sometimes I understand it. Your loved one is you feel like it's such a dire strait, you're willing to take any conservatorship, anything to get them into a safe place, just like if you were hungry or, your standards for what type of thing that you're willing to accept is a little bit different when you feel like you're just at your wits' end. So we definitely understand that, but this is the issue with a lot of people. They end up spending a lot of time and kind of spinning their wheels, thinking they can go one way or another. So if you're in those situations, obviously Jim and Gail are huge resources, but please feel free to reach out to our office as well. Number one, you cannot involuntarily commit people for psychiatric treatment, meaning they can't have access to LPS facilities, is basically it. The other thing is you cannot involuntarily medicate people on a probate conservatorship. Typically, when we consent to medical services or even every once in a while a psychiatric med under probate conservatorship, it's 99.9% of the time with that person's consent, even with whether they understand it or not. We want our conservatees on the probate side to be kind of in the same boat as we're working as a team. We can't just say, we can't tell the facilities that house our probate conservatees, hey, I don't care if that person doesn't want to take that med, give it to them anyways, right? Imagine what that looks like with especially our elderly population, right? Doesn't look great, but also none of these facilities are equipped for that. And of course, the timeline to get the permanent conservatorship can take not just months, but if something happens at a probate conservatorship hearing and the judge can't resolve it at that moment, they will continue it most likely 3 months out. So you can see if you have 4 continuances, you're already in the next year. So this obviously is a pain for a lot of families. And again, we're not talking about grave disability here. We're talking about capacity. And then, of course, it's forever. So there's different implications here. Moving on to the next slide. Talking about LPS. We'll skip most of these because, again, Jim and Gail touched on it brilliantly. But there's 2 sources that can refer. In LA County, I just want to clarify, it's not the jail that refers. Like, unfortunately, jail clinicians have a lot of other things on their mind in regards to the jail population. Typically, if your loved one is in the criminal justice system, again, most likely they will need to be deemed incompetent to stand trial because Penal Code 1370 and 1370.01 I put them in different slides if you need to look them up. But those are specifically designed to allow our criminal in other counties. But here we have a specific competency court in Hollywood. There's 4 courtrooms designed to settle these matters. And one of the things that that court can do is they can ask the public guardian to initiate a referral. I'm sorry, to initiate an investigation. So it's technically like a referral, but they order us to investigate whether someone who is currently held in custody at a jail is gravely disabled, whether it was a misdemeanor or a felony. So if that's the case, then we can investigate. Typically, we would never receive a referral from a jail because that's not the process that's set up here in LA County. So if anyone, I think there was some conversation, it looks like, someone was incarcerated. Like those are things that we can definitely talk about. But number one is that they need to be deemed incompetent to stand trial. And then they also need to be deemed ineligible or have already not passed through, or maybe they failed out of some of those other diversion programs that Gail and Jim mentioned earlier. And then I think we talked about grave disability. Let's move forward to the next slide really quickly. So these are the holds. I want to just differentiate really quickly. I think a lot of you guys are already pros on this call, but there's 3 terms that you should know is danger to self, danger to others, and then grave disability. So on a 5150 hold and a 5250 hold, you can be any of those 3 and qualify for those holds. So you can be a danger to yourself or be a danger to others or be gravely disabled, and a street team or law enforcement or whoever can put you on a 5150 hold. Same with the 5250 hold. Starting with the 30-day 5270 hold, you need to be deemed gravely disabled. So basically, the term gravely disabled is important for a lot of you families in how you're going to define that. As Gail and Jim mentioned, you're going to have the histories. And also, as they mentioned, these street teams, the clinicians, they are all obligated to make sure that they get all these histories from you. And if the people who are doing these jobs are good at them, they will want those histories coming from you because uh, at least from a personal standpoint, within the system, you don't want people cycling in and out of ERs and psych emergencies. You want people to get into permanent long-term treatment or at least short-term treatment instead of cycling through. That's not good for anyone, for that person, for the system, for the people who have to count the beans and pay the cost of those ED stays. It's not good at all, right? So these are things that if you guys ensure that once they're on the 14-day hold and you're not sure which way it's going to go, and you feel like the hospital or whoever is holding your loved one hasn't gotten all the histories, that's when you want to make sure you volunteer the information, as Gail and Jim kind of alluded to, as to their grave disability. Okay. And then, of course, during this process, I wrote down certification review hearing and writ of habeas corpus and Reese down there. There are other legal proceedings within these holds where the person has rights, the individual who is held has rights to either get off these holds and or refuse medication on these holds. So I won't get into the details of that, but if you're wondering why someone's not getting medication even though they're on a hold or how your loved one got off their hold, there are judicial processes built into each of these holds where a person can make their case to get off the hold because they no longer remain, gravely disabled or a danger to self or others, right? Moving on to the next slide. So again, LPS conservatorship referrals can be initiated by designated people. These are people specifically trained that also can put holds on people, but they're also specifically trained on the system. They're not just any, Tom and Mary that's a physician in the community. There are specific people, so they should be highly trained and understand the system. The reason why I bring that up, though, I have received several calls from people in surrounding counties that are not, I don't know how to say this in the proper way, but sometimes, if there's extra work, someone in the hospital may not want to do it. And I had a situation specifically with Orange County where it seemed like they didn't know, they didn't have our LA County LPS referral form. So then I had to call the hospital directly and say, do you guys not have our form? That is strange because you're designated within Orange County. You should have your surrounding counties forms. I sent them our referral form and they were able to refer to us to this person. So if you do have that situation where you live in a different county, but the residency of your loved one is actually in LA County, please make sure you make that case to the hospital. If they continue to fight back, please call us and let us know. You can email me directly because again, maybe they just don't know. There's staff turnover. There's a billion things that can happen where someone loses out the process of being able to refer to us. We want to make sure that we get the form over to them. So these designated facilities, they're specially trained and equipped to handle these psychiatric emergencies and psychiatric care. And again, I kind of explained that IST process, again, is if you look at Penal Code 1370 and 1370.01, those define the felony and misdemeanors that were able to be referred to our office directly from the courts. Moving on to the next slide. So once we get it, I mean, just want to be quick with this one. It's a big referral packet. You guys know sometimes clinicians don't have time in their day to really detail as much as they like. So oftentimes we get a referral and we have to go back and forth because we're missing a diagnosis, we're missing other information. So there can be some time, but to be able to send a referral to us, we also require that these facilities notice the person. This is a legal requirement. A person needs to get 5 days notice that a temporary conservatorship could be filed for them, or I guess against them in this situation. This is a legal requirement. If it's not met, sometimes we'll have to kick the referral back and say, we need to make sure this person is noticed because that's illegal, basically, right? It'd be like any other process, even though this is a civil process, any other process, even criminal, where you don't have enough legal notification in time to react to something. The courts want to make sure that you have your rights protected. So we need to properly notice the proposed conservatee. And again, this is all part of the situation where you as the parent or family member of your loved one, you may not want to assume that everyone in the hospital knows that process. So these are some of the things that you do want to just check into if you are kind of that deeply enmeshed in your family member's process to be aware of these things. So at that time, typically we'll look at the referral and then we'll open up the investigation, which means at the same time we'll ask for that hearing date and then file for that TCON to make sure that person is held safely in that facility until we can finish our investigation. Again, Jim and Gail touched on this. That person in LA County, 99.9% of the time, the court requires at that initial hearing date, before the end of the 30 days of the temporary conservatorship, that there's a hearing and that that person, the proposed conservatee, is transported to court. That's where they'll meet their public defender and they'll put their defense plan together. And that's where they can say, okay, I submit to the conservatorship, or the public defender may think, you know what, this is a very severe case. I think I'm going to recommend the proposed conservatee to submit to this conservatorship. And at that hearing, then the conservatorship can be granted. A lot of times people will contest, and that's a constitutional right that we respect. But then they'll ask for a jury trial, court trial, and then they end up being stuck in this hospital setting oftentimes for quite a while. So when they do that, these court trials, which is when the judge makes a decision, and the jury trials, they can kind of drag out for weeks. They try to do it as quickly as possible, but sometimes it doesn't get done in time just because of logistics. And then again, a lot of the holds, like a 5150, 5250, as I mentioned, they have kind of judicial processes built in where you become technically certified under the 5250 or 5270, meaning after the hearing, reviewing the person's rights, whether they should be on the hold or not, they determine, yes, they should be. And the legal standard for that is probable cause, right? Like you get pulled over for something, but if there's not something firm, the cops will say, you know, there's probable cause of you having conducted some criminal proceeding or something like that, right? And that, whereas in a court trial and a jury trial, the legal standard is the highest one that we use in this country, which is beyond the reasonable doubt that someone is gravely disabled. So that is why when you look at all the different holds, and if you track the data, you'll see that we place the most amount of 5150 holds, and then those numbers drop off as you get into the higher level holds, because not just that people improve through the time of treatment, but people, these people have other legal rights, including the right to a jury trial, which means, you know, if this jury of 12 people think, you know what, I have a little bit of doubt that this person is gravely disabled, then by rights, they should be saying this person is not gravely disabled beyond a reasonable doubt. Under different legal standards, whether it's like clear and convincing or preponderance of the evidence, there are lower legal standards that could be a little bit different. So I did want to clarify that. If you have questions regarding that, feel free to put in the chat or contact us directly. And then again, during this process, if there's family members, I just want everyone to know, Public Guardian loves families. If there's any, you know, if there's an experience you've had with our staff where it doesn't quite seem like that, that is not true at all. It might be the pressure of the situation. I don't want to make excuses, but we love families because we all know that you guys will provide the closest care, right? We have staff that are juggling 60, 70, 80 cases. Like if you had 80 loved ones that you're trying to handle, no matter how much you love them, there would be a bit of a bandwidth issue, right? So we do love families. They typically know their client the best. We want to make sure that um, if appropriate, that we nominate you, the family, as the private conservator during this process. Now, some of the questions would be, hey, how come you didn't nominate me? And there will be specific things delineated between us and you that need to get kind of mitigated before that. I won't get into that on this call specifically, but obviously you can always work with the investigator to kind of vet out what those issues are. Oftentimes, we've recommended family members, and this is just my personal recommendation, is how you present yourself to the judge at court matters a lot. In this judge is kind of putting themselves on the line to say, hey, I'm going to be okay with you as the private conservator. And if your conduct doesn't quite reflect that because of your frustrations of the process in that courtroom, I have seen times where at least one of the judges may say, you know what, I don't think you're the right person right now. They're gonna tell you, I want you to get your act together. The public guardian will be the conservator. We're gonna come back in 3 months and we'll see, if you sing a different tune, right? So unfortunately, it may seem sometimes a little bit demeaning almost to go through that process, especially as a loving family member. But we as the public guardian really want to support you in that process. And I think there are things about the system that are difficult to process and get through for you as family members, and those frustrations can build up. But please, I recommend heavily, don't let that frustration show in court. You can call me directly and yell at me about things that you may not be happy about, but you definitely don't want to represent that to the judge in court. And then, of course, this is probably something not every family wants, but typically we can also remove the petition if we feel like we found an alternate to conservatorship. Typically, that's like different programs that might be more appropriate than the conservatorship because the person's not highly acute. We often don't go this route too much when there's a private conservator available because we typically want to make sure that family members are involved in their care. Moving on to the next slide, I'm gonna just zoom through these because I think we're running out of time. So we covered all of these, and you guys will be covering these, so we can kind of skip the alternatives. Grave disability. So just really quickly, I know Gail, you were saying that you should probably touch this. We should start training on this right now. Actually, in that there was a bill SB 43 that changes the language of what grave disability means. Okay, so right now is a condition which a person, as a result of their mental health disorder, is unable to provide for his or her basic personal needs of food, clothing, or shelter. So you guys always knew it as one hand is mental health, on the other hand, food, clothing, and shelter. Now in 2026, Los Angeles County will enact a new version of that language. It's going to be mental health, a comorbidity of either mental health and substance use disorder, and then standalone severe substance use disorders. There will be trainings on this, but and then the clinicians who are on the call can clarify these. But a severe substance use disorder is under the DSM, where 6 out of the 11 substance use categories someone falls under consistently is considered severe, and lower numbers are considered moderate to mild, right? So these are the now 2 new categories under which someone can be found gravely disabled. And then the definition of grave disability is changed where they add, and this is not an and, it's a or, food, clothing, or shelter, or personal safety, or necessary medical care. So if a person is not able to provide for their basic personal needs of the typical 3 categories of food, clothing, and shelter, that doesn't change. But if they cannot provide for their personal safety or their necessary medical care, those are considerations where someone may be found to be gravely disabled. There's a lot of language on this, and we won't go over on this call, but that is something that has changed through SB 43. Most of the counties are enacting in January 2026. Some counties have already enacted. San Diego has enacted. I think San Bernardino has already enacted. San Francisco, Sacramento, San Luis Obispo. So we're seeing how that's affecting some of the other counties. But I saw that there were questions about substance use. So I think in 2026, that calculus will change a little bit. And then this is straight from the code. So you guys can kind of quote this. Moving on to the next slide. We went over all the powers kind of, not numbered, but these will be provided in the slides. Obviously, these are the powers that you guys are trying to get, um, or else there will be kind of no point to most of the LPS conservatorships, especially if someone is very severe, to be able to place them in a locked setting to make sure that they don't AWOL and go out to the streets and have something horrible happen to them. Those are part of the powers. Moving on, there's other things regarding LPS powers and restrictions. Um, so going to the next slide, this is the part about the estate. So usually you get person, and then sometimes you'll also get estate, and this is where you are responsible for safe tracking all their stuff. Gail, I have a question actually. Does NAMI provide a class on the fiduciary aspects of conservatorship?
Not to my knowledge.
Okay. There are many times where most of the times you guys won't have to really file official accountings, but there are some cases where someone has some money in their LPS estate, and then I would recommend probably if you feel like you're not able to handle those numbers, that you contact a professional fiduciary to try to figure that out. Let me think on what resources are there for that so that I can provide them at least at the next quarterly meeting, Gail.
Yeah. James, when you get the conservatorship, especially of the estate, the court can assign an attorney for you to work with for the year, and the attorney's free and accessible for helping you with any needs that you have, any legal needs.
Yeah, I think the thing is typically they don't do your bookkeeping for you, and so good like best practices for the conservator to do the bookkeeping part. I think those are good tips, especially if someone has a larger estate or actually has some assets, and maybe that particular attorney can also refer you to a specialist in those things as well.
Okay, I'm going to call you, and we can add that to the class for tomorrow. I mean, I'm not going to call you now, but in the next session when we do this,
Let's do
if
it.
you have any forms, yeah, we'll do
Yeah.
that. Okay,
Okay.
Can I say something on the subject really quickly?
Yeah,
sure.
go ahead.
Yeah, my name is Regina. My daughter was conserved thanks to Gail's help and back in 2017. And she had a little bit of money left in the bank from her husband's life insurance policy. And they assigned me an attorney from the courts to help me, but they put the bulk of her money into a special needs trust. And they kept the accounting. What we had to do is anything she wanted to buy, or she wanted, if she wanted to go on a little trip or whatever, it would have to go through me. I would, do the purchase, and then I would be reimbursed by the trust. And they kept the accounting because I had to show them receipts of everything that, we bought so I could get the reimbursement. But they kept the accounting, and they would send me an accounting. I can't remember if it was every 6 months or every year on that situation. So that was very helpful because I had no idea. I had never been through this process. But that was our experience with this.
I think that's a really good point, Regina, because there are some nonprofit special needs trust kind of agencies that do that kind of work for a very minimal fee. Obviously, I'm not able to recommend specific agencies or firms in my role,
Right.
but I think talking about those options, just like you brought up, Gail and Jim brought up CalAble as an option and other things, but specifically as to the court reporting, I think, yeah, if you siphon off through a trust, that makes it easier for you as a conservator because you don't have to touch most of it directly, right? You're just kind of like a pass through. So that's a great recommendation. But
And
yeah,
I think
Gail,
they had a limit. Like if a person had more than this much, then you would automatically go through the trust. And this is the attorney is the one that connected me with whomever the attorney offices were. So I was just there following their lead, and the attorney was appointed by the court, and he was extremely helpful and nice. So
yeah. So I definitely see the need to just at least touch on it briefly with people to because once they get into it, it's like, oh no, we didn't think about this part. And it is a little complex. And also sometimes you can be removed as a conservator if you don't do that financial part correctly. Obviously, for people who receive SSI, not as big a deal, but people who have complex estates, we do want to make sure that you're protected and informed on that. Moving forward, sorry, I am going to go over a little bit over. Let's just zoom through the slide. So these are the restrictions. Again, it's on the slide. We'll move to the next one. So this is something Jim and Gail, you guys touched on, but you want to remain involved in the care of your conservatees, and obviously that's why you guys are trying to go down this route. I wanted to touch on, so I know you talked about intensive care division. They're now called bed management within DMH. And they're the people where if you are on public benefits, they are responsible for a higher level placements within the county for the psychiatric care of your loved one. So I'm sure that they'll know what you're talking about if you say ICD or intensive care, but just want to make sure what that new name was. And they'll be working with the clinical team to get the right placement, but everyone should be noted, even though the clinical team at the hospital or whatever setting your loved one is being held at during the TCON, they will recommend what they think is the proper level of care, but the court is the ultimate decision maker. The court may not agree. You may want your loved one in a IMD, a locked setting, and the court may not agree based on the evidence presented to them. That means that person will the highest level is whatever that court decides to place. So I know that there's frustrations on that part as well, because you as a family up until that point, you're not really involved in the process except for us to nominate you as the private conservator. And then here you are, day one of your job, you're appointed as private conservator, but the level of care is not what you wanted. But you can always try to say, hey, I would like a rehearing on that. But typically, that's where you try them out at that level of care. And if that clinical team at that level of care feels like, you know what, the person is still way too acute, then the person may need to be rehospitalized acutely while seeking a higher level of care through the court. But that's the kind of evidence that needs to be presented at that point to show that a person a lower level of care may not stabilize that person. And you have to kind of go back through that. And then obviously you want to have the ongoing care and collaboration with the clinical team, with the conservatee, and then with the courts as well. I think we're towards the end of the slides now. I think the renewal part you guys will go over tomorrow, but again, don't forget your renewals, right? If you feel like your person has not stabilized, you do want to make sure you get on this process early and often. The public guardian sends out the declarations for reappointments more than 3 months in advance. So, you want to be prepared, know when your reappointment dates are. I'm sure you guys will remember that, but make sure you start working with that facility months in advance, because they can also say, you know what, I think your person has stabilized. I think they're no longer gravely disabled. And you may have a different opinion of that, and you want to work those things out sooner than later. Moving on to the next slide. These are kind of the differences and challenges. We go over them every time. So again, there's not enough beds in the state of California. If everyone who was deemed gravely disabled today needed a bed today, there would not be a lot of beds. Unfortunately, after the state hospital system was emptied out in the 60s and they kind of closed out, they never rebuilt the beds. They wanted community care, but they never rebuilt the beds for the community care. And so the counties kind of had to take up that role on our own. And we are building out beds and contracting slowly, but the particular quote unquote locked placements that a lot of families are looking for that long-term, or I'm sorry, that medium-term stabilization, there's not as many. So sometimes your loved one may get placed a little bit outside of the area that you want them to be. These are kind of just the realities of the situation that, we as the counties and the state, we do need to be better about, but building infrastructure, beds takes years and years. So there has been investment in the last like 7 to 8 years that I can see. But again, those are not just the county behavioral health, but like the state as a whole deciding to invest in that. I think we're out of time, so we can just kind of skip over to the last slide. Or is this one? Contact. So this is our main line. My contact info is in the chat. Again, please, if you have a question, feel free to email. I much rather hear it early on than later when we may not have a lot of room to maneuver. And again, if we can help a family figure out something early on, I mean, it's not to say that we don't want to do the work, but why not do less work today working with you guys than having to carry the full load later when you guys have been stressed out and frustrated to the point that you're almost wanting to give up. Please just let us know whatever issues you're working with. Just like that example with the hospital that didn't know how to refer, it may be something simple that we can get to the bottom of. So we do want to be proactive in our approach with the families.
James, that was excellent. Thank you so much.
Thank you, everyone.
Appreciate it. Okay, Dennis?
Good afternoon.
Dennis?
Yeah. Hear me?
Okay. Yes.
Okay. Good afternoon. Hi, my name is Venus Ngai. I'm the program manager for the AOT program, Assisted Outpatient Treatment Program of the Los Angeles County. So I know that most of the audience are the loved one and family member. So I think I try to maybe tailor-make my presentation to the audience and maybe throw in some of my personal experience with the program. And yep, so I think there's a lot of information, just like James, Gail, Jim. I think hopefully, I think you guys still stay with me, and attention. And then after me, Linda will also present about care call as well. Next slide, please. As some of you may have already attended this presentation in the past, but for those who is first time or may not know what is AOT. So AOT, in fact, last month, May 2025, in fact, is AOT 10-year anniversary. So AOT has been in LA County for 10 years. We do have a substantial history. And in fact, 24 years ago, as you can see in the picture, the 19-year-old college student, Laura Wilcox, were helping out as a receptionist in an outpatient mental health clinic and doing her winter break. But unfortunately, she was shot to death by individuals suffering from a severe mental illness. And as a result of the shooting event, and there's Laura's Law, and officially known as the Assisted Outpatient Treatment Demonstration Project Act was implemented. So this legislation, next slide, please. This legislation is pretty, you allow the county to use a court process to order individuals with severe mental illness who have a history of treatment non-compliance and at risk for treatment non-compliance or are at risk of deterioration or harm, and as a result, because they are not compliant, into outpatient treatment. So we can see that in LA County, so we basically have two treatment options. One, as Gail has mentioned about the full service partnership, we AKA also known as FSP. And another modality is called enriched residential services, also known as ERS. And in LA County, majority, almost all of the individuals, if they are outreached by AOT, they are linked to the AOT FSP program. Next slide, please. Through the intensive outreach and engagement process that I'm going to talk about, if individual refuse the services, AOT may petition to the mental health court to order individual into the psychiatric outpatient treatment, as I just mentioned, the FSP or ERS. And I would like to say it's pretty unique that, it expand the interagency collaboration among the court, the county council, public defender, now also had the Independent Defense Counsel Office called ECHO, and patients' right and the local law enforcement. Next slide, please. I would like to spend a little bit more time on this slide about the referral criteria. I mean, who will be qualified? Who will be potential AOT candidates? And so because it's a Laura's Law, it's not we have a referral form that we will talk about, but who will qualify? Basically, the number one is have to be an adult, 18 or above, and have a serious mentally illness. It's a treatable diagnosis, is the most updated DSM. And for example, Jim talked about the schizophrenia, major depression, bipolar, schizoaffective. Those are very common mental illness that we encounter and that document in the individual history. And also, I think one thing that we, when we receive a referral, we always look into with if there's the third bullet point about a history of non-compliance with treatment, and as a result of at least one of the following. And you can see I highlight in red and blue. So the first one is 2 or more hospitalization and or forensic mental health episode within the last 36 months. What I mean about hospitalization is not the medical, it's about psychiatric hospitalization. And the mental health, the forensic is talked about is not only in the jail, but they receive mental health treatment in the jail. We know that sometimes individual being arrested in the jail, they may not receive any medication or receive any mental health treatment. But what we talk about here, the mental health episode have to be, they are receiving treatment in the jail. And the second criteria, we talk about 1 or more act, threat, or attempt to cause serious physical harm to self or others within the last 48 months. So some of the example can be, you know, we know a family member, a lot of time you got the one who hold your loved one together, or hold your loved one at home, take care of them. There's a time that they get irritable, they get agitated, or they may be posture certain stance, aggressive stance at you, but there come at a time that they may or may not lead to some serious threat or act. For example, if they come, some serious act or attempt will be like punching someone in the head, push someone forcefully to the floor, hitting someone, or and your fear for the safety, he's throwing something at you, your fear for your safety, you have to run out of the house. Or making a serious threat at you, like I'm going to cut you out, I'm going to really shoot you, and then the person really have a means. For example, we know that we have some individual, they have firearm, they have access to knife, you know, and not only about some serious act harm to other people, there's also, they can be harming themselves. For example, we hear that individual maybe have ropes attempt to hang themselves. They may put a knife to that across the neck. They may use a cutter to cut their arm and cut themselves. Or they can jump onto the roof or attempt to jump off the window. Those are some of the things that sometimes I know family may not want to talk about it, but when it's time for you to think about is some of the things that will be able to qualify them to the AOT program. And what I would like to say is that sometimes you may not be sure, oh, I don't know, I think he go to a certain hospital, but I don't know which hospital, or I don't know exactly where he go because he may be homeless. So I don't know. I would like to say, put it down in the referral, even though you don't know, because for my staff, they have capability to look into the Department of Mental Health record, some of the hospital record and the jail record. We may be able to pull out the information, but of course, I think it'll be good that maybe sometime family member also have the information as well. And I will always say, you feel free to really call the line number that I'm going to provide, that you can always consult and email us or call us to consult. The fourth bullet point I would like to highlight is about a clinical determination that based on the treatment history and the current behavior that at least one of the following. The person is unlikely to survive safely or without supervision or is substantially deteriorating. I know that there's a time that we have a loved one that maybe many years ago, due to a mental breakdown, maybe, for example, lose a job 5 years ago, have been really maintaining that functioning. But by the time that AOT outreach, the person may be maintaining that function. So we'll monitor, but if we are going to continue to outreach, we are kind of monitoring if there's any substantial deterioration during that period of time. And deterioration can be by, as I mentioned, some act or threat or attempt to harm self or the others, or psychiatric hospitalization, arrest, jail time, law enforcement encounter, or restraining order, or neighbors calling the police, calling some disturbance. And there's also some increase in symptom that different from the baseline. And it will be something that can also maybe demonstrate that the person is really, the individual is deteriorating. So another point we talk about, the number 4, is that the person, the individual is in need of AOT to prevent relapse or deterioration, or likely lead to gravely disable or harm to self or others. There's one point that I highlight here, the number 4, about fail to engage in treatment. For AOT is pretty clear-cut. That means if the individual is linked to a treatment and is participating, we cannot accept the individual. But I know that there's some case that individual is really in a treatment but not compliant, not participating. I will encourage that you can always consult us and see, because we do see situation that maybe we think the individual, it seems like is participating, compliant, we do not accept the referral. But maybe after a couple of weeks, the treatment referral parties contact us, no, the person is really not engaging and really deteriorating, and we may accept back into AOT. The 5th point we talk about, and the 6th is pretty similar, we talk about AOT have to be least restricted placement. For example, if the individual can function well in, can be stabilized in the outpatient clinic or FSC level, then it's not the least restrictive. Or if individual is determined to be gravely disabled, is in the LPS conservatorship, of course, that individual need a higher level of care, and AOT is not the least restrictive. And also the individual have to be likely to benefit from the AOT program in order to be able to accept into the AOT. Next slide, please. Oh, sorry, I think I may have to click individual to have it show up. Yeah, so who can refer? We have a different category of the referral party that can as qualify as referring party, and I would like to in particular highlight the first 2 that most relevant to our audience, and maybe your family or your friends or beloved really you will consider refer. For example, someone who live together with the individual, for example, maybe boyfriend, girlfriend, roommate, fiance, niece, cousin, who live together. And the second category is about the close relative, the parents, sibling, spouse, and adult child. We have some situation that maybe you want to refer your uncle or your auntie who doesn't live with you, then it's not in the second category. But we can also allow you to be, for example, you can put maybe individual, the parents or the spouse as a referring party, and you are the one who fill out the referral form. So I think I have one slide that talk a little bit about this subtle difference. So I'm going to leave it here. And I want to go, the third one, talk about the licensed mental health treatment provider. I know that we have a lot of time that family may call the Department of Mental Health, the crisis team, just like the psychiatric mobile response team, the law enforcement team, to come to assess our loved one due to a crisis, psychiatric crisis. So in fact, they can also be a referral party. For example, no matter your loved one being placed on the hold or not, you can see, oh, can you commit a referral to submit to AOT? They are the even though they come and assess, but they have face-to-face assessment with your loved one, they are the qualifying referral party. Or if your loved one is in outpatient treatment or in treatment with FSP, but they are not stable. And even they can also be a referral party. You can also talk to them. Can you submit one as well? And another is that recently I encounter our AOT referral is increasing. I encountered that more and more referral from the mental health administration or insurance company. They may not be the qualifying referral party. So when my staff look at the referral, we may talk to them and say, okay, you are not the referral party qualifying. So maybe you can talk to your family member and have them be the referral party on the form. So if you are contacted by one of those party, so you will want to say, yes, please put my name there. You know, I'm more than happy to have you to refer my beloved to the program. And here I also mentioned about the number 4, 5 point is about those who stay in the facility that provide mental health service, and the director of the program can refer the individual to AOT, or they are staying in a hospital, the director of the hospital can refer the individual to AOT, or the one next to the last is about the police officer, parole probation officer, or the superior court judge can also refer to AOT too. Next slide, please. I would like to spend a little bit more time on this slide, you know, especially about the outreach engagement and the petition process. So when an AOT referral, you send it in, we'll prefer you email it in. So we receive it in the email or fax, and my staff will review the record, and we will contact the referral party and all the family to gather the information to determine whether the individual is eligible for the program. And the case are presented to the AOT referral review committee to determine whether we accept the case or not. If the referral is accepted, then AOT will start what we call outreach and engagement in the field for at least 30 days. So we will go to meet with the individual where they are. It can be at home, on the street, in the hospital, in the jail, or boarding care home, or homeless shelter. We provide psychoeducation to family. We provide support, explain what is AOT program, the process. And there's time one of the things very important about discuss the safety plan as well. And in this, I want to highlight the family involvement is very critical. A lot of the time, no matter to try to locate the individual where they are, if they are transient, they are unhoused, or if the individual live with the family. So we need to gain access to the individual. So family will be the one who are allowed to work with AOT, the team so that we can get access to make a face-to-face contact with the individual. And AOT will continue to assess so that the individual continue to meet the AOT criteria, and also assess for safety as well. Of course, we talk about AOT is really not a crisis team. So if there's really an imminent risk, have to call Department of Mental Health or call 911. Call the 911 or Department of Mental Health, the access line, to request for crisis evaluation. But we continue to assess for the crisis. And also, if needed, we also have capability to put individual on a 5150 hold as well. And we also work closely with law enforcement and the, for example, also Gail also mentioned we have capability to work together with the court linkage and the hospital liaison, the law enforcement team. Due to AOT have a long history working in the county, we do build a lot of collaborative relationship so that we follow individual throughout the whole outreach and engagement so that we can continue to advocate for treatment. So advocate to, if they're in the hospital, advocate to stabilize in medication, advocate for conservatorship. In the jail, we advocate for please, whatever program, the placement, and try to understand what's going on in the jail or the offense. So pretty much we follow individual throughout the outreach and engagement process and have a close communication with the family. And the ultimate purposes, of course, we want to build rapport and trust with individual, and hopefully we'll be able, individual voluntary, to participate in the outpatient treatment. But in case individuals say, no, absolutely not, I'm not, and walk away and just shut the door. So we can, AOT have the option to petition individual to the mental health court and order individual to outpatient mental health treatment. And as mentioned, AOT is a civil court and is not a criminal court. And we are not a, we are not LPS conservatorship. We cannot force medication, but we definitely would like to use the black robe effect for those who are able to likely benefit from this court process. And, you know, once the petition is sustained and an individual appear in the court and they attend the court hearing, so they follow the court mandate for mental health treatment. The process is 6 months, the initial treatment is 6 months, and it can be extended for another 6 months. And also, there are individuals that finish, you know, graduate, successfully graduate, and choose to have a voluntary treatment, you know, continue to stay in AOT FSP. But there's some that really need another 6 months, may need to be repetitioned. And there's also some other case that maybe they voluntary, but finally still kind of not compliant. Then may have to repetition as well. So we can, you know, in the past 10 years, we have various status, success, graduate, dismiss. So, but overall, I can really see a lot of the client, a lot of individual definitely get linked to treatment, and it just I think later on I'm able to maybe share some of my experience, some of my successful story. Next slide, please. So I would like to spend a little bit of time to talk about what AOT does or does not. So what AOT does, you know, in the in the mental health treatment, everything is voluntary. You know, in the past, you know, they talk about individual, they have mental illness. They pretty much say, I'm not sick, you are the one who's sick. They don't have insight. That's why they don't want any treatment. They don't want any part of it. We see a lot of people, maybe their first episode or just at the beginning, they really difficult for them to accept that they are mentally ill. So they don't want anything to do with it. So they are not willing to participate in any treatment. But with AOT, it's now there's an option for them to engage someone that they won't want to have anything. But now AOT try to engage them, try to go to them instead of you have to go to the clinic. And also some individual may not qualify for FSP. They don't have enough hospitalization record or jail. So AOT, we rely on a lot of the outreach and actively approach them and follow them, you know. So it makes those individuals used to be not able to engage in treatment. Now the option is available. And also besides conservatorship and locked inpatient facility, AOT also have an option for them to receive a FSP level of care of treatment. Instead of have to wait until I remember Gail saying, instead of wait until there really are actual violence, be arrested in the hospital, you know, there's something that AOT also continue to assess, continue to intervene. Hopefully that basically is to reduce the violence, you know, crime. Some of the individuals are unhoused, reduce them from being victimized on the street when they are unhoused, prevent law enforcement encounter, arrest, hospitalization. And we pretty much intervene before see the deterioration. Unlike 5150, you know, at that moment, they are imminent risk, they have to place in the hospital. But AOT do try to intervene based on the deterioration and utilize the black robe effect, the court process, to get someone to be able to really follow the court process and able to participate in the treatment. But at the same time, we always talk about AOT is strictly voluntary, right? So if someone say, I don't want to take medication, I really don't want to engage in this court process, you know, even though we court order, I don't want to participate. We do have some case like this. So we don't have any civil or criminal penalties for those who choose not to participate. Yes, we don't. We can only use, for example, someone who is not stable, who is someone not compliant. we can bring them in, the court can bring them in have more frequent hearing. And for those who are not compliant, for those who are deteriorating, we do have a 5346 hospitalization order. But someone we really encounter a few cases that absolutely never ever follow. And yes, we do have individuals that not able to finish AOT in a satisfactory way. And we do have cases that have to dismiss before going to the judge. But I think we do have a couple of cases that like that, but we do have quite a lot of successful story as well. Next slide, please. And here I also want to clarify a couple of things because I think I hear a lot, talking to a lot of family. Honestly, I spend a lot of time talking to family. Some of you guys may have talked to me in the past. So AOT is not conservatorship, and it's not something that you can definitely need to conservatorship. We definitely will advocate for it. And of course, a lot of time we personally, even I will advocate to the hospital or to the public defender. See, even this individual failed the process. Even AOT cannot get the person to comply. Please consider this individual is really gravely disabled. You can see we have all the history. Professionally, we line it up. Look, we're working with the family, we want to advocate. But it doesn't mean that we are conservatorship or we definitely can lead to conservatorship. We just work together to advocate for it. And another thing is that we don't have authority to mandate hold the person longer. We will advocate to have hold the person longer for stabilization in the hospital, but all are up to the treating doctor in the hospital. And I receive a lot of calls saying, oh, can you please expedite accept into the AOT program? And can you just start treatment right away? But as I mentioned, we at the process is outreach and engagement. We have to do at least 30 days. So the treatment is only when we link individual to the FSP or ERS, and then it's the treatment. And sometimes it does take time, just like what I explained. So be patient. It's a process, but we have to get individual a chance to voluntarily accept the service. And then we talk about the petition, and petition by itself can take at least a month or more than that, so be patient. And of course, we'll continue to provide education to the family or the loved one who know what's the process, what step we are going on. And also, I get called that, hey, Venus, my beloved is in hospital right now. Can you link someone to to a housing? We are not a program that readily link to housing. Usually, when individual link to a treatment program, then at that moment they may the treatment provider may be able to provide housing. But of course, I think if they are in the hospital, they can consider linking individual to crisis residential or shelter or other housing. But of course, individual can refuse. And as I mentioned, it's a process that we continue to assess for crisis, but we can't respond to call around the clock or immediately, oh, my loved one now at home at 3 o'clock, can you come right away? We'll try our best to be there. We know that sometimes it's very difficult to get in touch with individual, but we always try our best. But as I mentioned, we are county-wide program, so we sometimes will have to from Long Beach, and the team have to go to downtown LA or go to somewhere in Santa Monica. So it does take time, So as mentioned, we cannot force medication. Next slide, please. So here is a sample. I know I'm running out of time. Let me move on a little bit. This is the most, the updated referral form. If your form doesn't look like this, so that means it's outdated, please go to our website and get the most updated referral form. You can see a few areas, I box it. The red one is on the left, I put down name Jane Doe. If, for example, the green one and the purple one, for example, you are someone, for example, you want to refer your brother, sorry, you are the one you want to refer your brother. So your name, your referral party is Jane Doe, and then you are the sibling, and then on the right, the purple box, you don't know how to fill in. You want your son to fill in. You put your son's name there because your son is the one who filled out the form. But because he can't be the referral party, he doesn't live with, your brother, and also is not really the close family member. And then your brother live in an apartment So you may want the team to work with Kim, the apartment manager. So all this information are important, and then you will see that the candidate information will be, and then you put your brother's name. And the other part is pretty self-explanatory. I think it's this part that I figure out that a lot of people get confused. Next slide, please. Okay, finally, after I go through this, I want to bring one thing is, I think there's always hope. You know, it's really a close collaboration among various partners. And AOT, as I mentioned, worked for 10 years. We built a lot of relationship, and even law enforcement have referred their the client that refers individual they encounter to AOT program. We have track record working with different the MAD team, the LAPD, the SMART team, the RAM, the CAM, all those acronym, and then the court linkage, hospital liaison, or the home team, or various public guardian office. You know, I received call from in the past regarding public guardian office when the investigation asked about individual whether they meet criteria or not. You know, so I want to say we all work together. So I want to say this is something that not only about the partner, it's also very important about family involvement. All the AOT staff, they have a strong passion, including myself. But I believe that we only spend every week 1 or 2 hours or whatever time we spend. But family is the one, or your loved one is the one who spend around the clock. You guys are the heroes. You guys are the one who is there. You guys let us see the loved one. You guys are the one who is there day and time. Let us know what's going on. So it can be frustrated, but you know, it's something that please continue to help with us. So we see case the family refuse to work with us, then we can't really move the case along. And we need family individual who is able to let us know when the individual go or when we can't find them. So don't give up. I have story that everyone stay in my heart that I still remember no matter how long ago. Can be 10 years ago, 15 years ago, I seen an outpatient clinic doing well, but now deteriorate in the point that it's become homeless around the area, and they get referred to AOT. When I see individual, gosh, that's the person that 10 years ago really good functioning, but now to the point that homeless, really very psychotic, rocking around. So, and then of course continue to work the case, work with the law enforcement, and then get hospitalized, advocate for conservatorship, go to the court hearing, different things. So we have people that conserve, we have people that link to AOT FSP. We have people that I know that many years ago, almost impossible to work with unhoused, but now recently I was informed that individual get graduate from the FSP account. It's very unbelievable to me. So I think I want to say, you know, it's difficult to have your loved ones struggle through this process, but we all have very strong passion to work together with you guys. And next slide, please. So I think what I want to say is that somewhere in this slide, we have if there's a crisis, call the 800 number. The damage helpline is 24/7, or call 988 or 911. We also have the general AOT line number here. Feel free to call, and you can ask to talk to me, you know, and also have the email address, the AOT referral form. Please send through the email address here. And on the website, we have all the brochure in various language, and the most updated AOT referral form is there. And if you send the referral form email in, if you want to copy me so that I can eyeball it, feel free. If you want to call me or email me to have some consultation about Venus, how this works, I think some of the things I don't quite sure, and feel free, or I can have my staff to work with you to how to refer the individual to our program as well. And of course, I know that Linda is going to present about care code, and I know there's a lot of question about care code and AOT, and I think Linda will also talk about it. But basically, we also work very close together as well. So, thank you.
Thank you, Venice. That was really good. I appreciate that.
Thank you. Thank you.
Okay, Linda?
Afternoon. So I'm
Hey.
representing AOT. it's sort of this is like a sort of a new arena. So welcome everybody. And I think you'll see that what I'm going to talk about with Care Court is very, very similar to AOT, and we can talk about some of the differences later. So Care Court is brand new. It is was established by the Secretary of Health and Human Services in California. Gavin Newsom is very, I want to say, well, this is probably politically incorrect, so I apologize in advance, but Care Court is sort of Gavin Newsom's baby. And it was rolled out as a way to help get homeless off the street. And interestingly enough, when we look at our statistics and what we've seen in LA County, and I think it's been true in other counties, that 2/3 of the folks who are referred to Care Court are housed individuals. So there were originally 7 cohorts that began in California, and they started in October 2023. LA County was not among those. We wanted to be in the second cohort of counties, which started Care Court in December of 2024. But because we're a large county and because there was a lot of pressure from the state, and then our Board of Supervisors agreed, we started Care Court in December of 2023, a year ahead of time, a year of when we were supposed to start. So we sort of hit the ground running. Next slide, please. So CARE stands for Community Assistance, Recovery, and Empowerment Act. One of the things that's important to note is that CARE focuses on schizophrenia spectrum disorders only. Schizophrenia, schizoaffective disorder, unspecified psychosis, schizophreniform, atypical schizotypal personality disorder. Those are the criteria that qualify for CARE. So as you heard in AOT, any treatable DSM-5-TR, the latest DSM, any treatable DSM diagnosis qualifies for AOT. That is not true for CARE. There was a bill in the legislature, SB 831, that was going to broaden the criteria to include bipolar disorder. However, that bill died in appropriations, and so right now it is only a schizophrenia spectrum. So if someone has bipolar disorder with psychotic features, it does not count. If someone has major depression with psychotic features, it does not count. As Venus mentioned with AOT, with Care Court, it is also completely voluntary. And it feels like an oxymoron to me that there is a court order and it's voluntary. But that is the truth. And it does protect the person's self-determination and civil liberties. And I think we could have a lot of discussion about that, and we're probably all on the same page. But as it stands right now, that is what's happening with CARE. And the other piece about CARE that's different than any other program is that the county is ordered to provide the treatment. And if the county does not provide the treatment, then there can be sanctions leveled against the county. Now, if the person refuses the treatment, that's one thing that's different, but the county has to be able to provide all of the services that that individual needs. Next slide, please. So who is eligible for Care Court? And I might just mention the qualified, the eligibility requirements for both AOT and CARE, as well as the referring parties for both AOT and CARE, are mandated by statute. That's the law, so that we cannot change those, either who's eligible to receive the services and who's eligible to refer for the services. So in Care Court, we call the clients respondents, and they must meet all of this criteria. So you just go ahead and click them all, please. So again, they have to be 18 years of age or older. They have to be diagnosed with the schizophrenia spectrum disorder. So with AOT, they're not engaged in any treatment. With CARE, they made the requirement a little better and they are not stabilized in current treatment. So they could be seeing a psychiatrist, but not really taking any of the medication. They could be seeing a case manager in FSP, but not really doing well. So it's not that they're not in, most of our clients are not in any treatment. That's the reality. But they are, by statute, they can be in the treatment, but they're not really stabilized in any ongoing treatment. Again, the same with AOT, the individual's mental health is substantially deteriorating, and they're either unlikely to survive safely in the community without the supervision, or care is needed in order to prevent relapse and deterioration. And the same as with AOT, care must be the least restrictive setting, and the person is likely to benefit from the care program. Next slide, please. So who can petition? And this is where care diverts from, I believe, any other program, at least in the Department of Mental Health. And that is, so family members, spouse, parent, sibling, child, grandchild, or the person themselves can refer to care. And in care, it starts off with a petition to the court. So you as a family member can file a petition with the court. The court is Norwalk Courthouse in Department 95, and we'll talk about how to do that in a minute. So you can start the court process yourself. As you heard with AOT, you refer to AOT, they do the outreach and then do the petition. You heard with conservatorship, the hospital, the doctor examines the person, they fill out the application, it goes to the public guardian, and they file for the TCON and the conservatorship. Care is the one place where you as a family member can petition the court for treatment. The other folks who can petition the court are first responders, and included in that are mobile homeless outreach workers. So it doesn't require that there's a clinician on that team. The other people who are different are paramedics can also refer to care. They're not able to refer to other programs. So police officers, firefighters, mobile crisis teams who've always been able to refer to AOT or to care, homeless outreach workers. A hospital, the director of the hospital or their designee, so someone who is currently on a 5150, 5250 in a hospital, in an LPS designated hospital, as James has defined it, they can refer to care. A licensed a licensed mental health professional who has examined or attempted to examine that person within the last 60 days can file a petition. Someone who's over a board and care can file a petition. And in the community, in the county, DMH can file, public guardian can file for care, and the director of adult protective services. And that's totally new. I don't know of any other, outside of requesting a psychiatric mobile response team to come out and see their client. I don't know of any other program where APS can directly refer. Also, and there apparently are not any tribal jurisdictions in LA County, but the director of an Indian Health Services program or the judge of a tribal court can refer. And in fact, if someone is petitioned to care and they are a member of a tribe, the judge in care court must notify the judge in the tribal court that this person has been petitioned to care. Next slide, please. So this is what happens, and I'll try and go through this quickly. I know time is of the essence. One of the things that it's important to remember, well, let's just begin from the beginning. So you will file a petition. It goes to the Norwalk Courthouse, and right now it's one of the two judges who, Judge Herron and Judge Gilbertson, who were mentioned before, oversee LPS conservatorship court, AOT court. Judge Herron does AOT court, and both Judge Gilbertson and Judge Herron do care court. So the referrals are going, the petitions are going to them often. They're reviewing, and if it meets prima facie, then they send that petition to, that is accepted into care, and they send that petition to the Department of Mental Health. We go out and we do an evaluation of the client. We do an assessment of the client. We begin outreach and engagement as soon as we get that petition, which is usually within the week of the time the petition is filed and reviewed. One thing, and I noticed a question in the chat, one thing that is by statute, by law with care court that we cannot change is once a client is petitioned into care court, they receive a packet of information. We must go out and notice that person of every single hearing that happens as part of the care court process. And sorry, my filter is off, and so you can see my grandson walking back and forth. So the client is delivered a packet, and in that packet there is the petition. So unlike AOT, where we don't always have to tell folks who referred them with care, the law states that they must receive that packet, and the petition is in that packet. And I know that that presents some concerns for a lot of family members, and it presents some concerns for us as well. We're all on the same page with that. We do go out, we provide outreach and engagement, we provide an assessment. We have to do a report to the court that says we agree that this client meets care criteria. We may, while we're outreaching, determine that the client is engaged in services, and because of HIPAA, the family is not aware of that. So if the client is engaged in services and doing well, we ask for a dismissal. If we've outreached and we can never, ever find the client, and we're talking months, we may ask for a dismissal. But during that immediate assessment, we go out, we evaluate, we start the outreach and engagement, we write that letter to the court. Then the court sets up what's called an initial hearing. What's critical about that is that the petitioner must appear at that initial hearing. They can appear via WebEx or in person. If the petitioner does not appear, the petition is dismissed. At the time that the initial hearing takes place, the petitioner is relieved of the duties of being a petitioner. So they may get notice of the next hearings. If the client, and on July 1st of 2025, the law changes and says that the petitioner can get, even though they're no longer the petitioner, it is now Department of Mental Health that takes over that role. And that still that petitioner will get notice of every single hearing that takes place in care court. If the hearing is continued, why that hearing is continued. If they're dismissed, why they are dismissed. Right now, that's not what happens. Beginning July 1, that is what happens unless it is deemed to be detrimental for the petitioner to continue to get notice. So the respondent, your loved one's attorney, your daughter or son says, I don't want them to have any information. I don't want them to know about my hearings. They have to show a reason why that would be detrimental, and they present that to the judge, and the judge will make that determination. And I want that to be clear because often there's a lot of confusion about if you petition, you'll have access to everything. And that's just not true, and that's by law. What is true is that at the time of the initial hearing, when you are no longer the petitioner, the judge will ask your loved one if they want you to be a supporter. A thing that is unique about care court is that the client can have a supporter, a person who is with them, involved in every aspect of their treatment as much as that client allows them to be. So let's say it's your son and you are the petitioner, and we have the initial hearing, and the judge relieves you as being the petitioner. He's then going to ask your son, Sam, would you like your mother, let's say, who petitioned, would you like your mother to be your supporter? I thought that for the most part, clients might be upset their mother referred them and they wouldn't want them to be the supporter. And that, in fact, does happen. But interestingly, more often than not, Sam will say, yes, I want my mother to be my supporter. That means that you have access to all of Sam's treatment. You can be involved in developing his treatment plan that we're going to talk about in a minute. You get notice of every single hearing. You are involved in as much of his treatment as Sam wants you to be involved in. If Sam doesn't want you to be the petitioner, the supporter, the judge may ask, who would you like to be the supporter? Now, if Sam says he recommends his drug dealer, of course, the judge is going to vet that and say, no, Sam, your drug dealer cannot be your supporter. But generally, if it's another family member or something, then they also can be a supporter. We have clients who don't want anybody to be their supporter, and that's what happens. If we go out to see someone, even before we have that initial hearing and they need housing, we will try and get them connected to housing. So we do begin services immediately. Once we've had that initial hearing, and if we can't find the person won't open the door, they won't talk to us, we may continue that initial hearing, and that may get continued for several months, depending on how easily it is to access your loved one and how much we're able to communicate and provide services to them. After that, let's say they come to the initial hearing, they say yes, that they're willing to comply with some treatment. We start to form a treatment plan. And that treatment plan will always include medication. It will always include case management. It will always include therapy. And then it will include whatever else that your loved one needs. It may be helping to establish benefits, the SSI, the Medi-Cal that was talked about earlier. It may be to help them with substance abuse treatment. They may have a goal of at some point wanting to go back to school or wanting to be employed. Whatever they need, whatever is individually important to them is included into that care agreement. We present that care agreement, which is here called the care plan phase. We present that here to the judge. What happens is, and I forgot to mention, at every hearing, just like with AOT, an attorney is assigned to the client. County counsel represents the Department of Mental Health, and then there is the judge. So for a care agreement, the client and the treatment team develop that care agreement. So the client and the care team develop that treatment plan. It must be signed off by their attorney. It's signed off by the client, by the care team, by their attorney, and they are represented by the independent defense counsel attorneys who are under the umbrella of the public defender's office, but they're a panel of 50 private attorneys who have agreed to take care cases. It must be signed off by them. It is signed off by county counsel. It is presented to the judge. The judge must sign off on that care agreement. Sometimes the judge will add things that he or she believe is also important. Once the judge signs off on that care agreement, that's what starts the 12 months of the care program. So we may have outreached for a couple of months. We may have continued the initial hearing in order to get more information, to connect the client more, to be able to see the client and evaluate them more. And so when the care agreement is signed off by the judge, it may have been, we may have already outreached 2 or 3 months, and then they're still mandated to the care program for 12 months. If at the initial hearing, our continued outreach, the client says, pound sand, I don't want anything to do with you, then the judge orders us to go back out to evaluate the client again, and then come up with what's called a care plan, which for us is that same treatment plan. At this point, the client is not signing off on it. The IDCO attorney's not signing off. We present that care plan to the judge signs off, and that's when that 12-month begins. And so I've already talked about the supporter. And at the 11th month, we come back and there are progress reports that happen all along the way. So once that care agreement or care plan is signed, then we have ongoing progress reports where we come back and report to the court what's going well. We adjust the care plan or treatment as much as need be. And both for AOT and care, let me say the court is super, 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 super collaborative and super, super, super pro-client. And so one of the things that happens in care court is that the county is ordered to provide the services. The judge says to the client, you are the boss of this process. We don't have the same structure in place to be able to order that client to comply with the treatment plan. And the judge encourages, the judge cajoles, the judge speaks to the client a lot. And if any of you have been in either AOT or care court, you know that the whole focus is on what will help the client succeed, talks to the client about what they need, what can they, what's not going well, what can the department of mental health do to make things better. It is very, very client oriented, very focused on the client and what they want. There is no mandated medication. It is also a civil court. There is absolutely no stick if the client chooses not to comply. And the 11th month, that progress report contains what's going to happen next. And what happens next is if the client has been successful, they will graduate and we will step them down to a lower level of care, which for us is usually a full service partnership. Or they can decide to stay in care court on their own for another year, or we feel like they haven't met their goals and we ask that they be kept in care for another year. So it is 12 months at a time, and there can be up to 24 months to be a part of care court. Next slide, please. So in order to file a petition, there are, there's one piece of information for you. And the two things that I did not mention is that in addition to what was already the criteria I already gave you about the schizophrenia spectrum disorder, the deteriorating in the community, not able to live safely in the community without supervision, the statute also says that there should be 2 5250s, the last one within the last 60 days. Now, that's what is called that 14-day hold. And we know that you may not always have that information, especially since even when the client is hospitalized, they have to sign a release of information for the hospital to even tell you that your loved one is there. So you may have information if your son or daughter or whoever the family member is has given permission for the hospital to share information. You may know how long they've been in the hospital. You may know if they were on a 5250 or not. If the client has been hospitalized for more than 3 days, you can assume they are on a 5250. You just write down that information. There's a place for you to write it down on what is called the Care 100 form. That Care 100 is the petition that will be filed with the court. The easiest way to access that is through lacourt.org. It is fillable and you will e-file it, and we'll talk about that in a minute. And it talks about your relationship to the client, how you understand that they have a schizophrenia spectrum diagnosis, and it goes through the steps of those criteria that I have talked about before. There's a space at the bottom where you can put the hospitalizations. I can say right now the judges who are reviewing these cases are putting things through. So if you don't have all the hospitalizations, if you're not sure, submit that Care 100 form anyway, because the judges are being pretty lenient about letting things go through. DMH will come out and do an evaluation. They will talk to you. And we will look at our medical records, Department of Health Services medical records. We will look at everything we can. We will talk to you about any information you have to try and establish those hospitalizations. The other thing that can happen is maybe your son or daughter is seeing a psychiatrist and they're not really complying, but that psychiatrist or that therapist is willing to fill out a declaration saying they have examined your loved one or they've tried to examine them within the last 60 days. They fill out a Care 101. That also is at lacourt.org. And that also is then e-filed. So if it's just you and the person hasn't had any treatment, they've been hospitalized but no other treatment, you just fill out the Care 100 and submit it. If you have a therapist or a psychiatrist who has attempted to see your family member, you ask them to fill out that Care 100. If you don't have any information and we get that referral, once the court sends us that packet, we go out to see them. And if need, we verify that they do meet the criteria. And in that essence, we're filling out that Care 101. Next slide, please. And I'm sorry, because I know this does get to be a little confusing. The other thing is that the 11 courthouses in LA County that have family law in them also have self-help centers. And the reason that's important because Norwalk Court also has a self-help center, and that self-help center is just for care court. But embedded in that, and that's staffed by attorneys and I guess attorney fellows. But embedded into the Norwalk Self-Help Center are DMH employees, our care court team employees who are staffed there every day that the self-help centers are open. And we have a video capability to communicate with all of the other 11 self-help centers. So you can walk into any self-help center and they have a kiosk where you can get on video to the DMH employees at the Norwalk Self-Help Center. They can help you fill out the petitions. They can answer any questions. If your loved one doesn't have a schizophrenia diagnosis, they can give you Department of Mental Health referrals and places where you can reach out for care, for services. Even right now, even if your loved one has bipolar and you say, I don't care, I want to fill out a petition and file anyway, you can do that. The other thing about the self-help centers is suppose you live in Lancaster and you don't have the ability to get on WebEx at your house. You can go to the Lancaster courthouse, the Michael Antonovich courthouse, and go to that self-help center. They have a kiosk where you can appear at court through that, through WebEx, through that courthouse. And it is a private area where you have privacy and confidentiality. Next slide, please. Again, these petitions are filed electronically. You can bring them into the clerk's office at your self-help center. If you don't want to file them electronically, those 11 family courthouses, you can bring them into the clerk's office there. Next slide, please. So, it is not an attorney e-filing. You are e-filing. And next slide, please. And if you'll see, it will say filing services provided. You click on that, it will get you, it will allow you to e-file. There have been some difficulties lately with e-filing. If that happens, email me, and then I have the folks in the self-help group, in the self-help center, go down and bring your petition to the county clerk's office to file it for you. The fastest way is if the e-filing is working to go ahead and e-file it this way. There is no charge normally there's a charge to e-file forms. There is no charge to file for care court. Next slide, please. Next slide. So I've already talked to you about the hearings being in person. The other thing I forgot to mention that I do want to mention is that for many of the programs in the Department of Mental Health, they're paid for through Medi-Cal. The Department of Mental Health is not a part of any private insurance network. And one of the reasons that was explained to me years ago is that if we were a part of a network, then we would need to take any client that private insurance refers to us. And because the Department of Mental Health is specifically considered a specialty mental health service for those with serious and persistent mental illness, if we were mandated to take referrals from private insurance companies, then we might get filled with folks who had mild mental illness or just some issues that could be resolved with a few sessions of therapy. So most of the services in the Department of Mental Health are paid for through Medi-Cal. With care court, however, it is in the legislation that and when we bill private insurances for other services outside of our emergency services, they often do not pay at all. And then the client may be charged with the full share of cost. It was written into the care court statute that private insurances, once that care agreement or care plan is signed by the judge, that that care court services that the judge has deemed appropriate for that client must be paid for by private or commercial insurance. So where a full service partnership is not paid for by Kaiser, let's say, or by Anthem Blue Cross, as a part of care, that they must pay for the services that the client receives through the care court process. And right now, we do, DMH itself provides the therapy, the case management. We have psychiatrists on staff. Right now, there's just 2. We're hiring 2 more who are able to provide the medication and the treatment. Another thing that is happening is that we have ongoing meetings with the Public Guardian's Office because care is also considered a step-down program for conservatorship. So for clients who are no longer gravely disabled, and rather than have them go from being in an involuntary program to being completely voluntary on their own, we step them down to care court. And so they maintain the services that they already are getting through the conservatorship. They're probably already stable in their living situation. They're taking medication. They may be getting FSP services. We want to keep all of that in place, but then we will file that petition for that client, and then we will just sort of monitor, and the client still has a year of being under the court's purview. So Judge Heron, Judge Gilbertson will still be seeing that client, will be talking to that client, encouraging them, and it gives sort of a transition between having involuntary care to being totally 100% on their own. So we work very closely with the Public Guardian's Office to be able to have a smooth transition, and for that client to still begin to have ability, sorry, I'm stuttering here, still able to have that court supervision while being in a voluntary program. Again, there is no mandated medication. If folks don't comply with the treatment, even though the judge is telling them to, there is no stick. And so I know that gets very disheartening for families, and it's very disheartening for us as well. I think if the next slide, please. I've talked about the attorneys. Next slide, please. And again, you can access this through our website, but I think the easiest is www.lacourt.org/care. The petitions file, the 100-101 pop up. You can fill out the 101 electronically and submit it. Again, if you have difficulty, email that petition to me, lboyd@dmh.lacounty.gov, and I will have my folks at the self-help team try and work with you for us to either walk it down to the clerk or see what we can arrange to have it taken care of. Next slide, please. Next slide, please. And then as always, just as you know, these are the other ways to access care treatment through our department, through our LA County Department of Mental Health. The other thing I might mention here is that beginning June 26th, we are going to start a monthly forum for people who have petitioned to care or who are interested in petitioning to care. So we're setting that up now. There will be a public-facing link for people to join in. It will be the 4th Thursday of every month from 4 to 5, beginning June 26th, because often folks who've petitioned have a lot of questions, a lot of concerns. Just like in this meeting, we cannot address specific situations because of HIPAA, and we want to keep your loved one's information confidential, but we will, Nilsa Guiardo, Dr. Nilsa Guiardo, the other district chief, and myself will be on that meeting, and it will be a dialogue about the process, what you can do, what things are working well, what things aren't. And if there are specific issues, you'll be able to email us and we will deal with them offline. I believe I've covered everything. So I think it's time for questions for everybody, from everybody or for everybody.
Linda, thank you. That was awesome. It really was.